have a lot of my students up here, so when you see the Nebraska gear, okay, they came up here from Lincoln, so I really appreciate it. There was no incentive for you to come, was there? Yeah, okay, yeah, we talked, yeah. So anyhow, well, it's great. This is the first of our correction series, and Dr. Gaylene Armstrong, who I'll be introducing here shortly, will be telling you about the correction series. My job is to introduce her and also to Bob Cryne, because Bob Cryne's going to be the moderator. Can you hear all right? And Bob Cryne comes to us. Bob, how many years have we been friends?
About 40.
About 40, yeah. We worked together when he was a Douglas County prosecutor and when he was a federal prosecutor. Then he went to Washington, D.C., and then had the privilege of going over to Iraq to be on the team that prepared the case for the prosecution of Saddam Hussein. So that was quite an experience, and I think we text back and forth from Iraq as well. That was quite an experience for you. So anyhow, he's not in the area of prison litigation, so he's the moderator today. Now, I won't be introducing all the panelists, but my wife would really kill me if I didn't say something about Harold Clarke. So Harold and I have been hanging out. Well, I'm going to keep it at 4 decades, but it's actually about 4.5 decades. But anyhow, Harold was my mentor as I came up through the ranks of the department and as prison warden, and as he would move me around to different facilities as the warden, he would always say, "Now, Bob, this is going to be good for you." And so you're going to find he's quite a confident guy, but that confidence, that mentorship, always it also spills over onto the golf course. And so we were playing golf the other day up on number 17 here at Elmwood, okay, and I'm on the 17th tee, and I miss a 3-foot putt. And Harold says to me, when I used to miss 3-foot putts, okay, I always thought it was the golf club, but it wasn't. It was the golf ball. That's confidence. So anyhow, it's my pleasure to introduce my boss, Dr. Gaylene Armstrong. And I tell you a lot about her, but she has the type of personality you're going to know a lot about her. And I was talking to my wife, Donna, this morning. I said, this is really, hello, Danielle.
Hi.
Hey, good morning. I said, this is really exciting that Dr. Armstrong has turned me loose on this, to help facilitate this correction series. I mean, did you ever think in your wildest dreams that I'd be able to do this? And she goes, Bob, you're never in my wildest dreams. I didn't quite know how to take that. But in my wildest dreams, I never thought and never contemplated that my friend, Dr. Gaylene Armstrong, would come from Sam Houston State University to UNO and be my boss and turn me loose on a lot of projects, haven't you? So anyhow, Gaylene, she's got, there's the bio about her, but you're going to love to hear from her. Gaylene?
What a pleasure to see you all this morning in front of this wonderful panel. Thank you for joining us. I just wanted to share for a few minutes, since we have a whole variety of people here, from undergraduate students to our graduate students, folks from Douglas County, folks from the state, both practitioner and academic communities, but also a whole host of people who are being live streamed. So we're up on the technology from across the country. We have people from Wisconsin, Michigan, Minnesota. So while we have a room here of about 50 people, we have a whole host of people on the other side of the cameras as well, and that's thanks to the Nebraska Bar Association. So we're in good company today. But this event is hosted by the University of Nebraska at Omaha School of Criminology, Criminal Justice. We're an academic unit here at UNO. We're one of the top programs actually in the country. So it wasn't just Bob's winning smile that brought me here. It was the opportunity to work with folks like this here up on the panel, just fantastic people in the greater Nebraska area, but also a wonderful group of people at the university and the students as well. We have a great group of undergraduate students, master's degrees, and also a doctoral program that has a very long-standing history in the field. So very proud to be part of this. And as many of you know who are part of a university community, faculty and those who are involved in a staff role, we have a lot of different hats. The students will know that certainly we're here for the students to teach courses. The faculty know that we are also here to engage in cutting-edge scientific research, and hopefully as students you're hearing about that in your classes. But then there's another kind of third pillar that we talk about on campus, and that's service, both within the university, but for the School of Criminology, Criminal Justice, very importantly to our communities. And those stakeholders being either agencies, criminal justice agencies, legal entities, community organizations, all the folks that work together to improve public safety and improve our communities. And it's the heart of UNO to be very much engaged with our community, and that's what drew me here from a variety of places across the country that I've worked. Omaha and UNO has always been in my heart as a place I would love to be. So I'm very proud to be here as the director for the second year and meeting a number of people from across the country who are coming in to help sponsor this event. This year, one of the initiatives that we've undertaken is to create a series of informative panels. This is actually our first official UNO Corrections Workshop series, but 2 weeks ago we hosted, in conjunction with the Bureau of Justice Assistance and Arizona State University, a workshop on body-worn camera technology, evidence-based practices, and the like. And we had, again, about 50 people from across the country, law enforcement officials, policymakers, and so forth, here to learn more about implementing those kinds of things in our community. And now we're turning to the corrections side with a very hot topic, I suppose, that we had planned out well in advance of any excitement in Nebraska. We thought this would be a perfect topic to start educating from folks that have a wealth of experience and knowledge in the field and bring them together with attorneys, with students, with policymakers, and so forth here on campus. We have another couple of events already planned on November 3rd. We're bringing people together to talk about veterans treatment courts, which many of you know is very much on the forefront of trying to better serve system-involved folks who have a military background. We'll also be working on 2 workshops in the spring. One that is related to mental illness issues and mental health for system-involved people. And then something on Prison Rape Elimination Act, or PREA, and that'll be in the spring as well. All of these events will be posted on the Criminology and Criminal Justice website. Feel free to contact any of us that are part of the materials package and so forth, but we welcome you back not only to attend our workshops, but to visit our beautiful campus, to be part of our community engagement efforts. If we can ever serve you as an organization, criminal justice entity, or a student better, we would love to hear from you. So I hope that today is very informative and productive. A couple of housekeeping items. If you are here as either live streamed or in the audience as part of obtaining CLEs, do make sure that you've appropriately signed in. If you're here as a student, I know that there will be some coming and going with classes and other commitments. Please try to do so between speakers to not disrupt the audience, but we certainly understand that you have classes and things. Restrooms are right at the back, men's and ladies down the hallway. We'll have breaks, as you see on the agenda. There's plenty of beverages and food at the back with a little bit more to come, so please go ahead and be sure to keep yourself well hydrated and fed. We want you to leave happy. And certainly at the end, we'll be asking for some comments and evaluative comments. So we welcome that from students, both undergraduate, graduate, and our community partners, whether you're from an agency, an attorney, an organization. We want to know how to better serve you as part of these workshops in the future. So very fortunate to have a full room today and many people joining us across the country. Thank you very much for kicking off this event as part of our workshop series. We plan on continuing. And thank you very much to Bob Cryne for facilitating this event, while also being a UNO adjunct instructor who many of your students are here and already raved about you, if you don't know. Specifically some of the CJ ambassadors who are out front. The folks you see in the red shirts as you came in are some of our top undergraduate students, and they're called CJ ambassadors, and they volunteer for service with some of our events, and apparently they just love you, Bob, so you should know that. So without further ado, I'm going to go ahead and turn it over and welcome and enjoy the day.
Good morning, my name is Bob Cryne. I will be the moderator this morning. Before I make introductions, a couple of housekeeping points. First of all, because of the technology of the second decade of the 21st century, please put your cell phones in either the silent mode or on vibrate or turn them off. We're going to follow through the presentation today. I'm going to start by introducing our panelists. I request that you hold your applause until after all the introductions are done. First of all, we are honored today to have Chief Judge Laurie Smithcamp of the United States District Court for the District of Nebraska. She will lead off this morning, followed by Danielle Conrad, who is the CEO of the American Civil Liberties Union for Nebraska. Following Danielle, we'll have a break. After the break, Harold W. Clarke, who's the Commissioner of Corrections for the Commonwealth of Virginia. He's also held that position for some other states, including our own state of Nebraska, and we welcome him back to the Cornhusker State. And then J. Kirk Brown, who is former Assistant Attorney General of the state of Nebraska, who worked extensively in the prison litigation field. Welcome, Judge Smithcamp.
Thank you, Val. Good morning. The title to my presentation in your materials says that I'm going to be talking about the history of corrections and evolution. I didn't write that title, and I'm not planning to talk about the history of evolution. But if any of you want to talk about Darwinism or social Darwinism later on, we can certainly explore that topic as well. What I plan to do is talk a little bit about the history of corrections with an emphasis on corrections in Nebraska over the last 50 years, and particularly how inmate litigation has affected Nebraska over that period of time. As many of you may know, prisons are a relatively new development in world history. Many years ago, jails and dungeons were used simply for housing people who were awaiting trial or awaiting the execution of their sentences. Prisons were not used for the purpose of punishment. Punishment was generally execution, corporal punishment such as whipping, mutilation such as branding, or banishment. If you read about the Salem witch trials, people who were accused of witchcraft were kept in dungeons and jails awaiting their trial, and if they were found guilty, they were executed. If they were found not guilty, they were released, but then they were given a bill for their food and the straw bedding in their cells because the other people in the community didn't want to have to pay for that food and that bedding. It was expensive to feed and house someone, so most of the citizens thought, why should we pay to house and feed someone as a form of punishment? In the late 1700s, the Quakers developed the idea that prisons, that they referred to as penitentiaries, could be used to help rehabilitate people who had run afoul of the law. And if people could simply have an opportunity for solitude and meditation, surely they would see the light and develop religious leanings and be reformed. So the penitentiaries in Pennsylvania were single cell, solitary confinement units, and the offenders didn't talk with any other offenders or with prison staff. They were simply to meditate on their crimes, and that's how we get the term penitentiary. They were supposed to be penitent. This was an expensive project, and so it lost popularity. The more popular prison development was called the Auburn model, used in Auburn, New York, and it was in the form of a workhouse. Inmates were housed together, many inmates to a cell or dormitory style, and during the day they were supposed to be working. And that work then would help generate income, and that would help pay for the room and board. So it was a much more popular model. Those of you who have seen the movie Gone with the Wind may remember that after the Civil War, Scarlett O'Hara sets up a wood mill, and in the wood mill, she uses inmate labor. And Rhett Butler says, well, why don't you just use freed slaves? You know, they're cheap enough. And she said no, she wanted to use this inmate labor because it was cheaper. The inmates weren't paid anything, and they were practically starved to death. So that was the attitude in that era about inmates and inmate labor. In 1871, the U.S. Supreme Court addressed the issue of inmate constitutional rights and said they don't have any. An inmate is a slave of the state. An inmate has only those rights that the legislative branch, in its liberality, may choose to give to the inmates. And that remained the law for almost a century. In 1964, the U.S. Supreme Court again addressed that issue and recognized that inmates could in fact bring civil rights actions under 42 U.S.C. section 1983 for a redress of grievances regarding violations of civil rights under color of state law. So they could sue a warden, they could sue a correctional officer if that individual had violated their constitutional rights. So the question became, well, what constitutional rights does an inmate have that could be violated? And over the next couple of decades, the Supreme Court looked at those rights one by one under the First Amendment, freedom of speech, freedom of religion, freedom of association, freedom of press. Under the Fourth Amendment, unreasonable searches and seizures. Under the Eighth Amendment, cruel and unusual punishment. Under the 14th Amendment, equal protection and due process. And one by one, the Supreme Court began to recognize that inmates really forfeit only those constitutional rights that they have to forfeit for the achievement of legitimate correctional goals and objectives. The litigation that went up to the Supreme Court over that period included a number of cases from Nebraska. So prison administrators in Nebraska had their names emblazoned in the case law. Not Harold. Harold
got sued. It was Harold.
Harold missed out on that, and that was okay. But Warden Charlie Wolf is remembered in the 1974 U.S. Supreme Court decision, Wolf versus McDonnell, where the Supreme Court held that inmates in jeopardy of losing good time or being placed in disciplinary segregation have a due process right to written notice of the violation, a right to call witnesses and present documentary evidence if consistent with security, and a right to a written statement of fact findings. In 1979, Deputy Warden John Greenholz was remembered in the Supreme Court decision of Greenholz versus inmates of the Nebraska State Penitentiary. In this decision, the Supreme Court determined that inmates who are eligible for parole have a right to be heard and to receive an explanation of the reasons for the denial of the parole, but not all the due process rights that attach in parole revocation proceedings that the Supreme Court had delineated a few years earlier in 1972. In 1980, Director Joe Vitek of the Nebraska Department of Corrections had his name emblazoned in the Vitek versus Jones decision. The Supreme Court determined that inmates have a right to procedural due process before being transferred to a mental health institution. In 1981, Warden Bob Parrott was remembered by the Supreme Court in the Parrott versus Taylor decision, and this was a case that J. Kirk Brown argued before the United States Supreme Court and won. And it dealt
First
with
one of the three.
it dealt with inmate property rights and exhaustion of state remedies, and has since been superseded. Kirk may talk about that a little bit later on. So you can see Nebraska was relatively active in inmate litigation, and I think part of that was because the institutions were providing inmates with meaningful access to the courts. I began my career in corrections in 1980 after 3 years in private practice. At that time, Kirk Brown was the Assistant Attorney General, who was the liaison for the Department of Corrections. I worked very closely with Kirk. And Harold Clarke and Bob Houston were both working in the prison. I believe they were both in the programming area at that time, and they had a few years under their belts when I started. The Lincoln Correctional Center and Diagnostic Evaluation Center were newly completed. The old reformatory had been abandoned. The old penitentiary was still in use. This was the building that had been built in 1869 with some additions since then. But if any of you have toured Alcatraz, it looked a little bit like that on the inside. It had the long galleries with the cells with open bars, very little privacy for the inmates, up to 4 inmates per cell. The walls were riddled with bullet holes from machine gun fire that had been used over the years to quell riots. Only 2 women worked behind the walls. One was a nun and one was not a nun. Pornographic magazines were sold in the inmate canteens. Pornographic movies were shown in common areas. There were pinup posters of naked women in the work areas. I was told that those things and cigarettes helped to pacify the inmates. The prisons operated independent of the central office. 2 unfortunate things happened during the 1980s when I was there related to inmate litigation. Very early on, when I started in 1980, the warden at that time, obviously not Harold Clarke, was concerned about inmate overcrowding. He was worried that the department was going to get sued, that he was going to get sued about inmate overcrowding, and he didn't want that to happen. But the parole board wasn't cooperating by releasing enough inmates to help reduce the overcrowding. So the director decided to put together a list of all the inmates who had forfeited substantial amounts of good time and see which inmates could get out the door if their good time was restored. Inmates' good time was restored to a number of inmates who had lost their good time because they were really bad. And when they got out on the streets, some bad things happened. And one of those included a very brutal beating and rape of a woman who was working at the Ferguson House in Lincoln, and she was nearly killed. So it's a sobering thought that inmate crowding can not only be uncomfortable, it can not only jeopardize inmates and officers, but when correctional administrators try to deal with it by releasing inmates who shouldn't be released, it certainly threatens the public. Another unfortunate thing that happened during that era was a judgment that was entered against a couple of correctional administrators through inmate litigation. And this was a case, again, that Kirk was involved with. A fellow named Decabooter Williams, I believe, was placed in segregation, and he stayed there longer than he was supposed to stay there. The court determined that a warden, and I believe a deputy warden, had been deliberately indifferent to the fact that Mr. Williams was held longer than he should have been held in segregation, and a judgment was entered against these individuals. When the legislature looked at the facts to see whether or not to indemnify these individuals, the legislature said, well, if they were deliberately indifferent, that means their actions were intentional, not negligent, and therefore we are not going to indemnify these correctional administrators. So they had to pay the money out of their own pockets. Well, some of the folks working at the penitentiary thought that's not fair, it's not right. The department began to get statements for overtime work by officers at the penitentiary, and it was learned that the overtime was not actually worked, but it was paid, and the payments were given to the administrators who had these judgments rendered against them. So there was a shakeup. Some people were let go, some people were transferred, some people were demoted, and after certain openings became available, other people began to rise in the system. And I take a little bit of the credit for Harold Clarke's ultimate success, because our new warden, Charlie Benson from the Bureau of Prisons, Federal Bureau of Prisons, was looking for somebody to take the deputy warden position. And I said, Harold Clarke is highly qualified. He is your best man for this. I've seen him in action. I've seen him walk into the control unit in a riot situation and calm everybody down. He's bilingual. He's a strong-arm people. And Charlie said, well, he's in programming. You know, we're supposed to bring people up who are in the paramilitary part of custody. And I said, no, he can handle it. He won't disappoint you. Harold got that deputy warden position, moved on to be warden, moved on to be director, and has been in high demand nationwide ever since then. So I take a little bit, just a little bit of the credit for that. So those were the two unfortunate things that happened, the overtime scam and the release of the inmates. I'll mention a few very positive things that happened over that era. The Omaha Correctional Center opened. That was positive for many reasons. It helped reduce the crowding that we had in the Lincoln facilities. It also provided an opportunity for many of the offenders who had come from the Omaha area to be near their families, which made visitation easier since many of these families really didn't have transportation to get down to Lincoln. It also helped ensure that we could get a correctional workforce that was more diverse in the Omaha area because of the diversity of the Omaha population. An inmate grievance system was developed and certified by the Department of Justice, and the court system, federal courts here in Nebraska agreed through a local rule that inmates would need to exhaust that grievance system before they filed actions in federal court. This was good for a lot of reasons because the Department of Corrections could find out what was going on in the prison system, and if there was a problem, we had a chance to address the problem before it became too serious or before it led to inmate litigation. All of the Nebraska correctional institutions and the central office were accredited by the American Correctional Association Commission on Accreditation. We were the first system in the nation to be so accredited, and that means that we were following best practices. The corrections staff was sexually integrated. I headed the task force at the request of the director, Charlie Benson, to determine how and whether we could integrate the workforce in our correctional institutions so that women would be working behind the walls in the male institutions and vice versa in the female institution at York. He assigned to the task force, as the rest of the members, the wardens who didn't want to integrate the workforce. So it was me as the chair and a lot of wardens who said, over my dead body, we will never sexually integrate this workforce. One by one, we went down all the reasons why we could not sexually integrate the workforce. The women officers would have sex with the inmates. The women officers would have sex with other male officers. The women would get pregnant. The women would not be able to use appropriate force to defend themselves and to defend other officers. One by one, we eliminated all the reasons except inmate privacy, and we began to deal with ways to ensure that inmate privacy was protected. And as I mentioned, there were issues with privacy. We integrated the correctional workforce, and of course we got sued. We got sued by the inmates, we got sued by the male officers, we got sued by the female officers, and it was a triple class action. And Harold Clarke's wife, Marie Clarke, at the time Marie Powell, handled that case and ultimately prevailed on every point in the Court of Appeals, and that set a great precedent in Nebraska, and she's an amazing lawyer. Another good thing that happened is during that period of time, we were really the only state in the nation that was not under a consent decree, special master, or a standing court order for general conditions of confinement. And that was because in general, Nebraska was doing a good job with its prison system, and we had developed some credibility with the courts. Nevertheless, inmate litigation soared in Nebraska, due in large part to a few frequent filers like Billy Roy Tyler. At the end of the decade, nationwide, there were almost 50,000 inmate pro se civil actions filed, and the proportional filings in Nebraska were about 3 times the national average. In Nebraska federal court in the 1980s, inmates could file as many actions as they liked without paying any filing fees. They could subpoena state employees as witnesses without paying any witness fees. Inmates filed notices of lees pendens, that means a notice of a pending action, on correctional employees' homes. Correctional employees who changed jobs or moved away were still obliged to return to Nebraska to deal with inmate litigation that might drag on for years. Professional employees or contract workers such as doctors, dentists, and psychologists quit working for the prison system because they were in jeopardy of losing their professional liability insurance. In the 1980s, I was sued hundreds of times because I had served as the chair of the appeals board that heard the appeals of inmate disciplinary actions, actions that put inmates in segregation or caused them to lose good time. After my first child was born, I tried to buy life insurance, and the investigator did a background check, saw I'd been sued hundreds of times, called me up and said, "Are you contemplating suicide?" I said, "No, not yet." This pro se litigation also posed a challenge for the courts. It's certainly easier for a judge to manage a case that is well lawyered. So Nebraska federal judges asked the Department of Correctional Services to hire lawyers to represent the inmates. We refused. We did provide law libraries and trained legal aids. The federal judges then began to appoint lawyers to represent inmates in civil rights litigation. But there was no money to compensate the lawyers unless the plaintiff prevailed on one or more issues in the case. Then the attorney's fees could be awarded against the defendants. Lawyers began to balk at being appointed against their will in such litigation. The Supreme Court of the United States determined that lawyers could not be appointed against their will to represent inmates in civil rights cases. That led to a new problem. Federal judges began to ask lawyers if they would please handle such cases. Now, if you were a defendant in such a case, you might be uncomfortable knowing that the lawyer representing the plaintiff just did a big favor for the judge by accepting the case, and the only way the judge can repay the lawyer for that favor is by entering a judgment against you. And we saw some language in some of these cases suggesting that this did influence the judge's decisions. In 1989, I met with Judge Erbaum to discuss the glut of inmate litigation, and I suggested that the court consider imposing minimal filing fees. That year, Nebraska's federal court amended its local rules to impose a partial filing fee in inmate lawsuits. That new local rule reduced inmate litigation in this district by 50% between 1989 and 1991. In 91, I changed jobs and moved to the office of the Attorney General to work with Kirk and to head a section of lawyers handling the defense of inmate litigation. In 1993, I hosted a national conference in Omaha to meet with Assistant Attorneys General from other states who were also specializing in the defense of inmate litigation. We corresponded after that meeting, and soon we drafted legislation to address the issue of frivolous inmate litigation. Our proposal focused on 3 areas. First, the requirement that inmates be responsible for the payment of their filing fees, and a mechanism for the collection of those fees from the inmates as they were able to pay. Second, the requirement that courts dismiss actions that are frivolous, malicious, or fail to state a claim. And third, a 3 strikes rule, generally barring inmates from filing new actions if they have had 3 or more actions dismissed as frivolous, malicious, or failing to state a claim. Congress passed the Prison Litigation Reform Act of 1996, and that reduced inmate litigation in Nebraska federal courts by about 2/3. In 2001, I became a judge of the U.S. District Court. Nebraska's federal court has a heavy criminal docket, generally composed of cases that could be tried in state court, such as drug cases, gun cases, robbery cases. So in a way, I'm part of a system that helps to reduce crowding in Nebraska's criminal justice system. They're going into federal prison facilities instead of Nebraska facilities. I believe that all sentencing judges want to be confident that offenders who appear before them will be housed in facilities that are safe, secure, humane, and filled with opportunities for rehabilitation. So I thank all of the panel members here today, and I thank all of you for your interest in ensuring that Nebraska has such a system. Thank you.
First, we're going to hear from Danielle, Conrad, the CEO of the American Civil Liberties Union. Panelists, when you get to within 5 minutes, I'll give you a signal, and within 2 minutes. So after Danielle's presentation, we'll have a break, and then we'll continue. But please welcome Danielle Conrad.
Hi, good morning, everyone. Oh, sorry, thank you so much. Oh, thank you. It's always exciting when the technology works out. That's a good way to start the day. You just get, oh, wow, there we go. You're really high tech here, you know. Bravo. Hi, good morning. My name's Danielle Conrad. I'm the Executive Director of the ACLU of Nebraska, and let me just start by extending our incredible gratitude, my incredible gratitude to Dr. Armstrong, to Bob Houston, to UNO, and to my esteemed panelists and moderator for the event today, to have the opportunity to join you. It's a really important topic, and we always believe that additional education and awareness about these critical issues really helps us move forward together as Nebraskans. So I want to start off my presentation today with just a quick thumbnail sketch about what the ACLU is, because I came on board just about 4 years ago. This is my constitutional retirement job, as I call it, after being termed out of the Nebraska legislature as a state senator for 8 years. But I thought when I joined the ACLU, everybody knows what the ACLU does. Everybody knows who we are. And as I've had an opportunity to travel the state over the past 4 years and talk to diverse audiences, it's become very clear that not everybody knows who the ACLU is or what we do or how we do it. Maybe a few more today than about a year ago, but nonetheless, I wanted to just provide a little bit of context for our work in that regard. And then I wanted to provide some context for some of the issues that we're talking about today, and spend some time specifically talking about some prison litigation that the ACLU of Nebraska is involved in an effort to improve conditions of confinement in Nebraska's correctional facilities, and as part of our broader work to help to reform the system of mass incarceration that has been fostered in our state and sister states and across the country. Okay. That's me, Danielle Conrad, originally from Seward, Nebraska, represented the Fightin' 46 Legislative District of North Lincoln in the Nebraska Unicameral Legislature for 8 years. I was a member of the Appropriations Committee for all of those 8 years, and that was a really special opportunity to impact a lot of different areas of public policy in Nebraska, because anything that comes through the state budget with the price tag on it, we have an opportunity to weigh in. I had a nice opportunity to work with Director Houston, as he was Director of Corrections at that point in time, and to learn more about their work and the challenges that system faced at that period of time. I'm also an attorney, graduate of UNL College of Law, and so it's really fun to be able to now be at the ACLU and dust off my law degree a little bit and assist with some of our litigation work as well. So the ACLU is a 100-year-old civil rights organization on the national level. Our bedrock of our work is really grounded in First Amendment free speech work. That's what a lot of people know us best for. But as you can see with this timeline, our litigation and our advocacy work has touched so many different areas of critical civil rights and civil liberties issues over the last 100 years. And we like to say, when your client's the Constitution, you have the opportunity to work the waterfront and work on so many exciting issues, from First Amendment to Fourth Amendment to Eighth Amendment to equal protection to anti-discrimination and everything in between. So it's really fun to have an opportunity to impact so many different areas. And some of the highlights of our work that we're most proud of course, includes involvement in the Scopes Monkey trial, the Korematsu decision, challenging the internment of Japanese Americans unsuccessfully at that time, but still a seminal and critical case. playing a supportive role in Brown versus Board of Education, fighting for this free expression rights of students in Tinker versus Des Moines, working for women's reproductive rights and health, and then fighting for anti-discrimination, particularly as it impacts LGBT Americans. And our most recent significant win at the Supreme Court level was Obergefell versus Hodges, which brought the freedom to marry to all Americans. So we have, we're one of the largest public interest law firms in the country. We have a footprint in all 50 states and most U.S. territories. And today we have about 300 staff attorneys that work across the country on these different civil rights and civil liberties cases. In Nebraska, we've been around for 50 years. We just celebrated our 50th anniversary in 2016, which we're really proud to celebrate that milestone. It's important that we point out to folks we're entirely privately funded. We receive no government support. That's for a variety of reasons. One, because we typically only sue the government, and that might be a little awkward and may impede our ability to carry out our independent mission and objectives. But it also ensures that we're responsive to the community and the community that supports us. We are governed by an 18-member board of directors. We have 7 full-time staffers and a contract attorney, a small but mighty staff. And then we're pleased to extend our capacity and our work by working with private attorneys all across the state that help us to screen cases and our cooperating counsel as we bring our litigation forward. We have over 10,000 dues-paying members all across Nebraska in every legislative district in this great state, and we have over 20,000 online activists that take action in support of our different campaigns. So we do our work in 3 primary ways. It's a sophisticated program of integrated advocacy. Okay, what does that nonprofit speak mean? It means we do litigation, we do policy advocacy, and we do community education and empowerment work. And we work to complement those strategies to advance our civil rights and civil liberties objectives. So to the task at hand today. What's the problem? The problem, the overarching problem, the context from which we're working on these critical matters today and moving forward is mass incarceration. It's a system of mass incarceration that is present in Nebraska, that is alive and well in Nebraska today, that is present in many of our sister states, even though they're starting down the path to reform, and that's present in our country. America has the dubious distinction of being the largest jailer in the world, and we incarcerate a significant portion of our citizens, far in excess of the percentages that we see in almost any other country. So how big is this problem? And, you know, one thing I didn't mention in my bio is that we have 2 little ones at home, a 5-year-old and an 18-month-old. So I don't know if it's the mom in me that really is moved by this statistic, or if it's just so shocking that anybody can relate. But our system of mass incarceration has grown so unwieldy in Nebraska that today, about 1 in 10 Nebraska kids will have a parent in the criminal justice system at one point in their life. Let that sink in for a minute, to think how big this system is and how unwieldy and how many lives it touches, not only for those that are incarcerated, but for family and friends that are left behind in our community. And not only the loss of time and resources and energy that happens when those parents are behind bars, but the lifetime of collateral consequences that come with a criminal conviction and how that impacts those individuals, those families, our community, and our state. So there's the other piece that's critical to know about mass incarceration from our perspective is that this is squarely a racial justice issue as well. Our system of mass incarceration has significant racial disparities at every single juncture in the criminal justice system, from initial stop to disparities in bail and bond, to disparities in charging, to disparities in incarceration, and the list goes on and on. To give you an example of that, our demographics in Nebraska, roughly about 10% of our population are from communities of color. Those that are incarcerated in Nebraska's prisons right now, about 50% from communities of color. So it's not really a close call there. There's significant racial disparities and institutional racism at each and every aspect in our criminal justice system. And that's something that we have to just be prepared to talk to. We have to be able to address it, and we have to figure out a way to ensure our system can be reformed so that it is more equitable and more fair moving forward. So in Nebraska, this is something that is really surprising to a lot of people as we go out and talk about our work. About half of those that are incarcerated in Nebraska prisons are there presently for nonviolent offenses. And unfortunately, Nebraska, despite the fact that we have amongst the lowest use in the country for illicit drug use or even in seeing overdose deaths, we have one of the highest rates of arrests and incarceration for drug crimes. And that's really a driver in our system of mass incarceration and the present overcrowding that we see in our prisons today. And something that's good to know, because those are issues that we definitely can look at experiences and models that have played out successfully in other states to divert nonviolent offenders to more effective responses to criminal behavior, whether that's through treatment or services or other sorts of appropriate sanctions or programs and services that address that root cause and that don't truly become an ongoing burden on the system and have poor outcomes for the individuals that are struggling with behavioral health issues. So today here, and it's such a perfect segue after Judge Smithcamp, who's one of my heroes, by the way, so it's kind of a fangirl moment to be on a panel with her today. But she, I think, provided such eloquent and informative context for where the Nebraska system has been over recent decades, and this is a good opportunity to kind of catch up from that timeline. So where are we today? Today in Nebraska, it will be no surprise to anyone here today or watching at home, if you're from Nebraska in particular, not hardly a week goes by when we don't see a story about our crisis-riddled prison system playing out in our newspapers or on our television stories, whether it's deadly riots, whether it's escapes, whether it's a continual onslaught of frontline staff assaults, or just the incredible overcrowding that's happening in our prison system. And to be clear, it's something that impacts all Nebraskans, not just those that work inside prison, behind prison walls, or those that are incarcerated behind prison walls. It's a huge driver in our budget. It's a huge driver in our economy, and it's something that we all need to be really thoughtful about in terms of how we move forward. So according to the most recent metrics available, Nebraska stands today as the second most overcrowded jurisdiction in the country. We are system-wide at 160% of capacity, and we have some facilities that are even over 300% of capacity in our prison system. Under state law in 2020, if the prison system is at an emergency level, which is delineated at 140% of capacity or more, it's not permissive, it's mandatory. In 2020, the governor will have to declare a prison emergency and start to work towards prisoner release orders and alternatives to the present system of incarceration. So 2018 is right around the corner, and 2020 will be here before we know it. The 140% emergency trigger used to be permissive in state law until about 2 years ago, when the legislature, as part of a broader package of criminal justice reform legislation, made it mandatory. So there's a hard deadline out there that state officials are looking at and are going to have to work within. The other thing that's important to remember is that, particularly in Nebraska, with the significant amount of nonviolent offenders and drug offenders in our prison system, the vast majority of those incarcerated Nebraskans will return to our communities at some point. Well over 90% of those incarcerated will return to their families and their communities at some point in time. But I think what's important to note is that not only does our system have extreme overcrowding, but our system has extreme underfunding and under-resourcing when it comes to ensuring that we have that we are able to meet basic standards for some critical programs and services like healthcare and particularly mental health care. Over half of those that are presently incarcerated have a diagnosed serious mental illness, and as things stand today, the prison system doesn't have a psychiatrist on staff. And has incredible vacancies all across the behavioral and mental health positions that are there to meet the basic and critical needs of those that are incarcerated. Okay, so how did this happen? It's no one factor. There's no one silver bullet. It didn't happen overnight, and we're not going to get out of it overnight. It didn't happen with one single issue or factor, and it's not going to be resolved with one single issue or factor. And so I want to tick through some of the big drivers of mass incarceration and to help to identify what those are and then how we can address them for reform moving forward. So the first factor is what we call the state house to prison pipeline. And what this means is this is a deliberate policy choice over decades by our state leaders, particularly in the Nebraska legislature, who've doubled down on bad policy. Whether that's the failed war on drugs or the tough on crime mentality, but they've passed bill after bill after bill after bill after bill after bill that creates new crimes or that enhances sentences for existing crimes. And so that, in culmination, has helped to foster and create and perpetuate the system of mass incarceration that Nebraska finds itself in today. Now, to be fair, some initial, meaningful, and important first steps to reform to peel back and stem the tide of that state house to prison pipeline have been instituted in Nebraska over the last couple of years. But the unfortunate fact is that the projections through reform measures like LB 605, which were projected to bring down the prison population, are not working. The most recent data shows that, in fact, the prison population has continued to increase, not decrease, over the last couple of years, further exacerbating overcrowding. And some of these other intersections and interplays with these other factors that drive mass incarceration, I think, are causing, are undercutting the ability for that reform to be effective. So another factor that's critical in driving mass incarceration is what we look at as a lack of accountability for prosecutors. And I think that it will be no surprise to this sophisticated audience, but this is something that a lot of lay audiences are always really surprised and confused about when we talk about this, is that really prosecutors are the most powerful players in the criminal justice system in many ways. They wield such broad and significant discretion to charge and to bring cases forward. And what we're seeing is a trend of really what we believe to be overcharging criminal defendants, and that really impacts the existing trends that we see, where many criminal defendants who either can't access attorneys or who are facing significant jail sentences and punishments opt to take a plea deal. And the vast majority of those never get before the judge, never get before a jury of their peer, but instead, because of this incredible power that's invested in prosecutors, this is really driving mass incarceration as well, without a lot of accountability. Most prosecutors run for their positions unopposed, and most citizens don't know a lot about the role that they play in their communities. There's just not a lot of attention for how those individual discharging decisions impact our system of mass incarceration, and I think public education and accountability in that regard is really an emerging trend that we'll start to see in Nebraska and is playing out in other states. So of course, jurists, judges have a critical role to play in the criminal justice system, but again, many of the cases never end up before them because so many go into plea beforehand. And when they do, there's an incredible lack of discretion because of extreme sentencing laws like mandatory minimums, habitual criminals. Laws, things like that. And until very recently, there was not a great deal of meaningful alternatives for jurists to work with criminal defendants to provide a different and more responsive alternative to incarceration, whether that's problem-solving courts or treatment programs. Now, we're starting to see that change a bit in Nebraska and other places, but that's something as Judge Smithcamp noted that does weigh heavily on the minds of jurists as they're making decisions about what's best for that individual and society as a large. Is there a meaningful alternative to prison to achieve our same public safety objectives? So our system of mass incarceration, while we see the state house to prison pipeline passing more and more laws to criminalize more and more behavior, on the flip side, we're not seeing legislators make the requisite investments to support that decision in facilities, programs, services, and staffing within our program system. So that's when you get a real disconnect between the public policies and the resources requisite to steward those public policy choices in our prison system. We see in Nebraska what we believe to be a broken system of parole, which is primarily driven by the fact that for a lot of people that are presently incarcerated, in order to be parole eligible, they need to work through some programs and services to address some of the issues that were significant factors in their criminal behavior, and that hopefully will put them on a more successful path when they return to our communities. But because our system is so under-resourced and understaffed, there's a lack of options and access to those programs and services that people need in order to meet their parole eligibility. So it becomes kind of a vicious cycle that really impacts the ability to move more incarcerated Nebraskans into the community through supervised care and ensuring that they get the kind of programs and services they need so that they don't reoffend, and we can push down our recidivism rate and have better outcomes for the individual and for public safety. And as we've been putting together some of our policy advocacy and our litigation in this regard and talking to experts around the country, and they're looking at the numbers of Nebraskans who quote unquote jam out. This might be something that you've heard about the Nebraska prison system where people don't go through this supervised release process but serve their time and go out without maybe having the ability to avail themselves of critical programs and services. And the numbers that we see for jam outs in Nebraska far exceed what we see in other institutions, in other jurisdictions. And this is an ongoing public safety concern, I think, for all Nebraskans and part of the broken parole system there. And then, of course, the political considerations that factor into all of this. I can tell you, having worked in the political arena, both as a campaign consultant and as an elected official and a candidate, you don't get a lot of points in the political arena for standing up for people who are really shunned by society and who are very vulnerable. Those who commit criminal infractions and transgressions against their neighbors. And so you definitely don't put it on the mail piece when you're running for re-election that, wow, I really helped to ensure that prisoners have basic services or accommodations to meet their disabilities. I mean, those just aren't the driving factors in our political arena. And so, in fact, it works out the opposite way, where in the political arena, people really beat you over the head if you try and come out in support of more thoughtful reforms as being soft on crime or as coddling criminals and impacting public safety. And so there's a real risk, I think, for elected officials to lead in this regard, and that's a driver as well. Okay, so the ACLU of Nebraska has been involved in a host of prison litigation over the course of our 50-year history, and I won't go into all of those cases or activities, but I thought that I would highlight two of our most recent cases and then talk specifically about the recent class action that we filed this summer. So Gilpatrick and Weatherhall versus Nebraska Department of Correctional Services. This is a case actually that was started before I came on board, but was just a decision was just handed down by the Nebraska Supreme Court a few weeks ago, actually taking us back to the starting block on a procedural error. But what the underlying theory and issue in this case is that we're fighting for the rights of two incarcerated individuals to get married. because the freedom to marry means the freedom to marry for everyone, including those that are incarcerated. And there's clear case law on that emanating from the United States Supreme Court, and we're in a tussle with the Nebraska Department of Corrections about how to effectuate that right, appropriate to risk and some other factors. So justice is not swift, and that case has been litigated for about 3 or 4 years at this point in time, and we're back to the district court level to amend the complaint, and hopefully, of course, if there's an opportunity to settle, we'll always look forward to that, but that's one case that we're working on right now. It also doesn't make a lot of headlines in our work, but we do a fair amount of individual advocacy work as well. There's not a day that goes by that our office doesn't receive an intake from somebody who's incarcerated, or an inquiry from a family or friend member who's concerned about somebody who's incarcerated. In fact, we receive dozens of these intake requests, typically on a daily or weekly basis. Some of them are entirely frivolous or not related to a civil rights or civil liberties issue, and so we're unable to help, or we refer them to other people who might be able to. But the ones that do present a significant civil rights or civil liberties issue, our first opportunity always starts with informal negotiations and reaching out to the Department of Corrections to see if we can address that individual claim that might pop up. The emerging trend in our individual work right now that has really continued to pop up is the rights of transgender inmates and the special accommodations that they need to meet some of their needs while incarcerated. And to their credit, we have been very grateful to work with the Department of Corrections to address many of those issues without the need for litigation. But that's just a few examples of our work in that regard. So Sabata versus Nebraska Department of Corrections, this was a case that was a long time in the making. I think the ACLU of Nebraska board actually voted to authorize this case while I was still in the legislature back in 2014. And this case is a case that we filed this summer in August 2017. And we were proud to bring this case forward with what I believe to be one of the most talented and experienced team of litigators ever assembled in Nebraska history. We're so pleased to be joined, and I see one of our friends here today in co-counsel, Ken Smith from the Nebraska Appleseed Center for Law in the Public Interest, has signed up to assist. We're joined by the ACLU's National Prison Project, who has expertise in litigating these cases all across the country. We're joined by the National Association of the Deaf and Hard of Hearing to talk about the individual disability rights issues at play in this case. And we're additionally pleased to be joined by two significant private counsel. Piper DLA, which is the second largest law firm in the world, brings considerable firepower and resources to help bring this effort to fruition. And then Rosen and Bean, which is a boutique civil rights shop in California that handled the Plata case, the overcrowding case in the California prison system successfully. So we are pleased to have that incredible team of litigators assisting us with this important endeavor. We have 11 named plaintiffs in the case with females, males, people from every correctional facility system-wide, and people that are representing, through the facts of their case, a variety of the claims and theories that the case is centered in. At its heart, this is an Eighth Amendment case. This is about deliberate indifference, cruel and unusual punishment for those that are incarcerated, and particularly the lack of meaningful access to medical care, mental health care, and dental care. Those are the real drivers in the case here. There's also claims on the Rehabilitation Act and the Americans with Disabilities Act, particularly for those that are incarcerated with special needs and disabilities. So as we are talking about this case, people say, like, you know, how does it help the system if you guys get rich on this case? And, let's just take a moment to disabuse people of what the remedies sought in this litigation are and in these cases typically. We're not seeking money damages. This isn't about money. This is about policy change, and this is about ending suffering, human suffering that's needless. And the fact that even though these people have run afoul of our criminal laws and deserve punishment, no one in our community should be tortured during their time of imprisonment. And that's what's in Nebraska prisons right now, whether it's the extreme over-reliance on solitary confinement, and particularly those with mental illness whose illness is exacerbated by that position, or if it's just a lack of basic health care. One of our named plaintiffs had a broken femur that was not attended to for 7 years. And you can go through and read the 11 stories that are detailed in the case for the 11 named plaintiffs. And to be fair, I want to take a moment to acknowledge that the rights and values that we fight for in the Constitution and through our litigation would stand hollow or ring hollow if good people weren't willing to step forward and fight for their rights. And whether it's the plaintiffs in our marriage cases or the plaintiffs that step forward behind prison walls at a risk of potential retaliation and opening up the most intimate aspects of their lives to public scrutiny, I really admire people who are willing to step forward, take that risk, and to fight. And so what we're seeking is the end to the needless pain and suffering. We're asking for basic access to mental, physical, and dental health care. We're also asking for accommodations for those incarcerated with disabilities and with special needs. Let me tell you a little bit about a few of our plaintiffs that fall into those categories. We represent one gentleman who is blind, primarily as a byproduct of diabetes, and he has been continually denied basic aids like a braille block or a talking alarm clock or getting to and from the mess hall or his medical appointments or having his walking cane removed for punitive reasons. We're representing an individual who is deaf and has never had accommodations for seeking medical or mental health treatment with an ASL interpreter so that he can engage with his medical professionals in an appropriate way. We're representing two individuals with a severe mental illness who've been housed in solitary confinement. The Nelson Mandela rules say the best practices should be no more than 15 days. We've got documented cases in Nebraska where people are being held not for days, not for weeks, but for months and years. So when we talk to our national experts on the outside, they're looking at what's happening in Nebraska and they say this isn't normal. This doesn't happen in every prison system. And these are real outliers that we need to address. So we're hopeful that we will see a fresh look at policy reforms of the state legislature. We're hopeful that the state of Nebraska will come to the table and negotiate a settlement. And if not, we're prepared to go the long haul through federal court litigation, which has been filed and now is seeking class certification. Okay, so how do we fix it? We can't build our way out of it, because unless we fix the front end and unless we fix the back end, it's build and build and build and build and build and build and build, and the state budget won't sustain that. And we no longer have the luxury to attack this system at one discrete part. We have to look at it from a comprehensive perspective. So we have to do front-end sentencing reform. That means peeling back on extreme sentencing, reforming mandatory minimums, looking at the habitual criminal laws, looking at indeterminate sentencing laws. We have to provide more front-end opportunities outside of incarceration for a meaningful response, whether that's through problem-solving courts, mental health care and treatment, or other diversion services. And we have to also, at the same time, we have to walk and chew gum at the same time. We have to do it all together. We have to secure additional investments on the inside. We have to infuse money and services into the prison walls now to ensure that frontline staff have the support that they need to do their job, and that those that are incarcerated are getting access to basic programs and services that they need to meet their health needs, their dignity, and to eventually successfully work through the parole process and have a successful reentry to our communities. And on the back end, we need to look at what other states are doing for innovations in parole and probation to ensure that those that can be returned to our community safely or through supervision have an opportunity to do so, and then that have a successful support at that point of reentry. We know from studies in other states, for example, that the greater ties to communities help to reduce recidivism. Some things that we can look at, even outside of the typical criminal justice reform arena, include restoring voting rights. Civic engagement has shown to help strengthen community bonds and to push down recidivism rates. We have to remove barriers to accessing basic things like food nutritional support for returning citizens as they get back up on their feet. And we have to remove lifetime barriers to things like finding a good job, which is a top driver in reducing recidivism and ensuring a more successful outcome through ban the box activity, through looking hard at licensure reform, and through encouraging businesses to step forward and to give a second chance to returning citizens. So the bad news is we have a lot of work to do, but the good news is in this beautiful democracy and these great laboratories of democracy we have from our sister states all across the country, we're not asking Nebraska to do anything novel, unique, or that's never been done before. We're asking them to look at successful models of reform that have played out in other states, with political landscapes and demographic factors just like Nebraska that we can bring to Nebraska to make a positive difference for those that are incarcerated, for those that serve them on the front lines, and that impact all of our collective public safety goals as Nebraskans moving forward. So there's a host of additional resources there that you can go take a look at, including a guide to prison litigation in the 8th Circuit, which we published in 2014 and are refreshing actually as we speak. And then there's an additional series of partners that we work with on these reform measures, whether it's Right on Crime, who comes to this from the conservative perspective, ACLU Smart Justice Campaign, the Council of State Governments in Bureau, which provide a lot of technical support and expertise. But let me leave you with one hopeful thought, and in full disclosure, I'm an optimist by nature. But the cool thing about criminal justice reform today is that this is still an area where there's a lot of consensus and agreement, where people are coming together across the political spectrum, maybe for different reasons, but to say this can't stand and we can do better. It's not every day that the ACLU stands hand in glove with the Koch brothers in the halls of Congress, or every day that the ACLU stands shoulder to shoulder with the Platt Institute in the rotunda of the Nebraska legislature calling for smart criminal justice reforms. But that shows that people of goodwill across the political spectrum can and should continue to come together to ask for reform and to ask for a brighter future. So with that, thank you for your time and attention, and looking forward to your questions later today.
Good morning, ladies and gentlemen. We are going to pick up with our presentation. Our next speaker will be Clarke from the Commonwealth of Virginia. Please welcome Commissioner Clarke.
Good morning. Thanks for coming back. After hearing from Judge Camp and Conrad, 2 excellent presentations, I figured you probably thought you had enough, you know, and the excellent presentations have run out. So, no, I'm challenged here now this morning. There. I really appreciate the opportunity to be here this morning to share with you. I was asked to speak on a Director of Corrections perspective to inmate litigation. Now, that's a major task, given the fact that Directors of Corrections can be quite different. We come from different walks of life. You can't assume that we all come up in corrections. I did, starting out as a counselor and working my way up. But today we have Directors of Corrections who are generals, are attorneys. We have a lot of law enforcement personnel coming in as heads of corrections today. And so when we get together, the 50 directors, it's usually very interesting conversations, because the room, there's so much diversity that exists in the room today that sometimes you have a hard time coming to a consensus on certain issues. But I will do my best to speak about how directors generally feel about inmate litigation. And I'm going to use some stories to talk about my feelings and how I got to where I am today in response to inmate litigation. But I will say to you that inmates and advocates on their behalf sue departments of corrections on a variety of subjects. But mostly, I think they're suing today on issues such as the alleged failure to provide adequate medical services, restrictive housing, mentioned by the last presenter, also referred to as segregation, general conditions of confinement, to again include overcrowding, and religious practices. I have some information. Let me just share it with you quickly in one of those areas, because we are involved in litigation right now in Virginia involving provision of medical care, because we have had a couple of deaths at an institution. And I'll talk about that case a little later on. But people are alarmed by the fact that someone will die in a prison, even after receiving medical care and medical treatment, that someone will die. But people die all the time, all over the place, prisons and in the community at large. But why are we alarmed sometimes when folks die in prison, especially when 80% of the offenders that we have today in the Virginia system and in other states as well, 80% have an addiction to alcohol and or drugs, and they came to us that way. Then they become addicted while in prison. 56% of females and 18% of the males in our system are on psychotropic medications. Mental health disorders are 6 times higher amongst the offenders population than those in the community. And while I worked as Director of Corrections, the Commissioner in Massachusetts, and now Director in Virginia, these numbers are the same, in that 60% of the women have a mental health diagnosis, and 24% of the male have a mental health diagnosis. And hepatitis C is disproportionately higher in institutions amongst offenders than we will see in the community at large. And it's estimated that 12 to 30% of all offenders locked up today have hepatitis C. A major, major challenge that we're facing, and that we're beginning to see a lot of litigation in that area as well. And in Virginia, 50% of the offenders are enrolled in 1 or more chronic clinics for care. So we have a very sick population that comes to us with a lot of challenges, and we provide medical care for them. But whenever someone dies, there's always someone out there willing to take on a lawsuit to make allegations about failure to provide adequate medical care, which is something that people like myself, correctional administrators, often finds quite troubling. We, as correction leaders, seek to prevent litigation whenever possible. We try to stay abreast of legal precedents. That's one way that we do so. We work closely with our legal counsel to make sure that we understand the court rulings, and that we are implementing those rulings, that they're reflected in our practices, that they're reflected in our policies as well. We do other things such as make sure that our facilities are engaged with best practices. So we seek ACA accreditation to make sure that we are doing all the things that we need to be doing in terms of medical care and access to courts and you name it. All the things that ACA identifies as practices within corrections that we ought to be not only doing but doing well. We seek accreditation for those purposes. We also, in Virginia, as well with ACA, when it comes to PREA accreditation, we make sure that we have a cadre of staff trained as PREA auditors, that is the Prison Rape Elimination Act, trained. And we also have auditors trained in the ACA standards to make sure that we're at the cutting edge. We understand what's required, and as a system, we are able to implement those things. But regardless of our best efforts, we still end up in litigation. We are glad we are truly glad that there are attorneys and advocates who make it their business to look out for the offenders' rights who are in our care. We often share the same goals and objectives. Directors see what we perceive to be lots of frivolous cases, our opinion. We think they're frivolous cases. Others may disagree with us. But we also have to acknowledge when we see cases that have merit, and we do so. And when we see a credible case, I believe that it's incumbent upon us to take action. Whether that action involves some type of action against a staff person because of their behavior, or whether or not it includes making a change in policy, or whatever solution or action that it's going to take to protect the rights of the offenders who are entrusted to our care. We do all that we can to avoid litigation short of settlements that are not going to serve the best interests of the correctional process and public safety. Some believe that litigation is necessary to bring about positive change in corrections. Well, I strongly dispute that position. I don't think that litigation is necessary. Correctional practitioners are always evaluating policies and practices to determine what changes are necessary, what changes should be made to bring about better outcomes for all within our care. Occasionally, we go beyond those standards as well. For example, as it pertains to PREA, long before the standards were implemented, in Virginia, we began training every staff member and every offender. When I say everyone, I mean everyone. The 12,000 plus staff in Virginia all went through PREA training to make sure that they understood what PREA was all about. We developed videos and so forth to make sure that everyone was reached and understood and could ask questions. And so it's no surprise that every one of our facilities is PREA certified in Virginia. And that's how we choose to approach the challenge. We're not going to sit back and make excuses. We're going to take a look at the issues and we're going to do what's necessary to get the job done. The same thing with ACA. We are satisfying ACA standards in every one of the 46 institutions in Virginia and in our probation and parole districts as well. Let me give you one example of something that I did when I got to Virginia that did not occur as a result of litigation. It just happened because after arriving, I saw a situation and I felt that something needed to be done because we could be doing better by the offenders that were housed there. And this is a situation that involved the Red Onion State Penitentiary. Upon arriving, and some of you have probably read about Red Onion and you've probably seen an HBO documentary on Red Onion not too long ago. I would love to have you ask me about that film at the conclusion when you have a chance. There's a long story there. But when I arrived in Virginia, there were 511 offenders at the Red Onion State Penitentiary, which was a supermax prison, designed to be a supermax prison by the legislature. Offenders were locked down in that institution 23 hours a day. They were the worst of the worst offenders in Virginia. Virginia has 39,000 prisoners. 511 represented the worst of the worst, and they were locked down at Red Onion 23 hours a day. They could have been placed there by a warden from an institution just assigned them there, or they could have been placed there by through the classification process. But once you got to Red Onion, you had no projected release date from that restrictive housing unit. So when I got there, reviewing data, I realized that 58 of those individuals from that institution in 2010 had been discharged directly from Red Onion to the community. No, while at Red Onion, every time they move in restraints with 2 officers, no matter where they're going, inside that facility or outside. And again, these are dangerous people. Believe me, they're dangerous people. But to release 58 of them directly into the community, I thought was not providing responsible public safety. So I said something needed to be done about that. So without additional support from the legislature, I brought my team together and we found the resources to build a school at the Red Onion institution. We implemented cognitive restructuring programs accessible to every offender in that institution. We created a class of correctional officers that we call corrections program officers, and we trained them to deliver cognitive programs, which they did then and still do in uniform, to try to break down that issue that presents itself, the problems between officers and counselors. The offenders. We wanted to have the offenders see the officers delivering programming in uniform to shift perspectives and change stigmas. Today, of that 511, we have 164 offenders in segregation, in that classification at Red Onion. That institution is no longer considered a supermax because it's mostly general population. We reduced that SEG unit, restricted house unit, by 72%. And as a result, before that, over the last 6 years, of all of those who have stepped down and discharged, only 29 have done anything to revert back up to higher security. And the only way they step down is upon completion of the programming that was determined by the clinicians that they needed. And only 29 have done anything to revert back up to a higher position. We received an award from the Southern Legislative Conference for innovations in government as a result of that program. We received recognition from the Department of Justice as a result of that program from the Obama White House 2 years ago because of the work that we have done at Red Onion. And 58 discharged directly in 2010. That number has fallen gradually. In 2016, 4 offenders discharged from Red Onion to the community. And this year so far, 1 offender has discharged from Red Onion to the community at large. It's a safer facility. The staff will tell you it's safer. The offenders will tell you it's safer. And the climate is totally different. But I'm dismayed to say to you that after all of that, advocates today are still coming out the woodworks and trying to find ways to sue us over Red Onion, as opposed to joining forces with us, trying to figure out how we can potentially improve upon that situation. While serving in Nebraska as the director for about 15 years, I was sued on an average about 40 times a year. Judge Camp played a part in helping to save me. Kirk Brown as well, and a whole team of lawyers that were involved in providing support for the agency. As a corrections director, I must share candidly with you that inmate litigation have angered me. I felt like a victim. I felt disrespected. I felt unappreciated. I felt disappointed, misrepresented, and all those apply at any given point in time, depending on the case that we have been dealing with. And yes, sometimes I took it personally. but you quickly get over it. Otherwise, you just simply would not survive. I'm going to share some stories with you by the way of true cases that would go back to helping you understand why I felt the way I felt over time in terms of inmate litigation. Some of them, you probably are going to shake your heads because you'll say, man, I can't believe a federal judge would have done that, or whomever would have done X, Y, Z. I didn't believe it at the time either, but it happened. And everything I say to you, you can go back and you can look it up. It's all a matter of record. I'm going to share with you 5 or 6 cases given time. And I'm going to share as well that I think that a lot of these cases could have been addressed outside of the courtroom. The issues could have been addressed outside of the courtroom, and we could have come to some type of understanding. My first case, my first lawsuit that I can recall was while I was serving as an assistant superintendent at the state penitentiary at the trustee dormitory. I was sued by a Native American offender because he alleged that I was not providing Native Americans equal access to the music room at the trustee dormitory. Now, I was troubled by that lawsuit, first of all, because if you know about my progression, my career, at one point in time, I was the advocate by job, title, position for the Native Americans at the state penitentiary. I was the person responsible for making sure that their religious rights were being realized. I was the person that built, at the direction of the director, I oversaw the construction of the first sweat lodge at the state penitentiary, which I think is still standing there today, which was a day-long process. I even had a chance, not that I knew when I was getting into it, to sit down and smoke peyote with some medicine men who came in whose bags were not searched. But I was told by my bosses that I need to accommodate them, make them feel like they were really welcome, and to do as they instructed me to do. So we participated in a sermoning, a bouncing ball ceremony, which we passed the pipe, and lo and behold, when I tried to get up, I could not. So after working that close with the Native American offenders, to be sued by one claiming I was not providing access, I took that one personally. I was disappointed. I was somewhat dismayed over that. I was troubled that a case of that sort would get to federal court. But it did. But I shook my head. We went to court. The judge found for me and the department to dismiss the case. The second case I'd like to share with you was while I was serving as the warden at the state penitentiary. And this particular case is one in which it is very clear that prejudice and bias exist throughout our country. It exists in the court system. Judges display bias. Judges display implicit bias as well, if not deliberate decisions. But while serving as the warden, I was accused as being a member of a plot to murder an offender. No sooner than the offender's documents, his suit hit the courts, Director Frank Gunter, and Judge Kent may recall this, but Director Frank Gunter received communication from the court directing me not to have anything to do with making any decisions in the case of this offender. It seems like we were in court within a week and a half to 2 weeks after we got notice. And the plaintiffs, of course, put on their case first. And at the conclusion of presenting their case, the Assistant Attorney General, who was defending me, made a motion to have the case dismissed. The judge denied the motion and then said these words that I will never forget. He denied the motion and he said, "Those who have been oppressed, when placed in positions of authority, may be inclined to be oppressive." That was just before the lunch hour. We broke for lunch. The two young ladies who were representing me went back to the AG's office and told Deputy Attorney Pat O'Brien what was going on, and he came to the courthouse and he took over the case from that point on. I remember he banged his fist on the table when we resumed, and he had a few words to say to the judge. The judge put his head down and listened to him. And when Mr. O'Brien got through speaking, the judge raised his head and said, "Counsel for the defense occasionally have cause to be emotional. Let's proceed." And we went on with the case. I found that to be troubling, something that I will never forget, something that tells me that judges are human beings, that judges have their prejudices, that judges often display implicit bias when they don't even realize what they're doing. And needless to say, we presented our case. I recall this case went for about a week. And the entire time I was in pins and needles, not knowing what to expect coming from this court. Ultimately, the judge found for me and dismissed the case. A case that was totally fabricated, not one shred of evidence. I'd never even recalled speaking to this offender. But I got hauled into federal court and had that lesson from a respected federal judge by many. The third case I'd like to share with you, and let's fast forward now several lawsuits. I have been through Nebraska. I moved on to Washington State, and then I decided to leave Washington and go to Massachusetts. So I arrived in Massachusetts, and there was a case that some of you may have already heard about. It was a case of Michelle Kosilek. This is a case involving an offender who wanted to have sex reassignment surgery and to be paid for by the state. The case was heard approximately a year and a half before I arrived in Massachusetts. This case was before the judge, and the judge had not made a decision yet for about a year and a half. Upon learning that there was a new commissioner in town, the judge reopened the case, set a hearing date, and ordered me to present myself at this hearing. This is what I say is somewhat bizarre. I'm not sure that anyone has experienced this before, but I showed up in the federal court in Massachusetts. In the room was the media, a full courtroom, the plaintiff and her attorneys, and two assistant attorney generals seated at the table. I showed up and I sat in the courtroom, just like you're sitting right now in the audience. The judge came into the room, the court was gaveled into order, and the judge looked around and said, and asked, "Is Commissioner Clarke in the room?" The Assistant Attorney General said, "Yes, Your Honor." And he looked around, the judge looked around, and said, I was pointed out to the judge. The judge welcomed me to Massachusetts. And then a very unusual thing happened. For approximately 30 minutes, the judge took time to explain, talking almost to me, this case on Kosilek. and how important this case was. He then asked if I am willing, he says, is Commissioner willing to enter testimony into this case this morning? And I just sat there and looked at him. And he turned to the Assistant Attorney General. Generals. But they agreed with me. And they cleaned it up. And they went back and told the judge that the commissioner is not prepared to testify today in this case. The judge then ordered that I read the testimony and the deposition of the former commissioner entered in that case, and that I read the deposition and the testimony of the expert witnesses in the case. And then he gave me 30 days, he set a trial date, for me to come back and testify in this court on this case, give my opinion based on what I read. But a very unusual thing happened before we left. Before we left, he called me into chambers after he dismissed. So the plaintiff's attorney, my attorneys, and I are back in the judge's chambers, where he proceeded to tell me how this was a matter of life and death. Quote, this is a matter of life and death, and this is a very important case to him. We left his chambers. The media was waiting for me in the hallway. They descended upon me. The AG took me literally by the arm and pulled me out the courthouse. And we left the courthouse. It gets better, folks. And again, this is, I'm sharing this with you because this is what happens to us in litigation, how we feel. So, I got away from the media. I get home the following morning. I opened the newspapers. And in the newspapers, a Massachusetts senator by the name of Brown, which some of you make the connection now in a second, a Massachusetts state senator by the name of Brown, who went on to win the seat of former or the late Senator Ted Kennedy. This, at the time, state senator told the Boston paper that he would work to have me removed as commissioner if I didn't testify in opposition to the sex reassignment surgery. So I'm about 2 months in Massachusetts. This is my introduction to inmate litigation in Massachusetts. And I'm saying to myself, well, first of all, isn't that tampering with a federal witness? And he did it publicly in the newspapers. I'm about to testify in a federal case, and he's telling me if I don't testify in a given way, he was going to have me removed as the Commissioner of Corrections. I mentioned that to the AG, but they didn't want to fight that fight. So that was just dropped. So I showed up approximately 30 days later. Only witness. The judge proceeded to question me first. After probably a couple hours or so, it seems like an eternity, he gave leave to the plaintiff's attorneys and the others to question me as well. The hearing was concluded, took about 4 hours or so, and we left. I left Massachusetts about 3 years later. A decision still had not been entered in the case at the point that I left. While in Virginia, a decision was entered. The judge found for the plaintiff, ordered the state to do the sex reassignment surgery. the state appeal, a panel of the First Circuit Court of Appeals found or sustained the judge's decision. The state appeal for review en banc, and the entire First Circuit Court of Appeal then reversed the judge's order, and the U.S. Supreme Court refused to hear the case. So, I have some other cases, and you know, these things, when I begin to talk about them, it seems like yesterday that they happen, because some of these things you can't forget. And the other cases, I've had two others, but I don't have enough time to get into all of those, but they pertain to inmate litigation on death row. And I would be glad to speak to them about those, but there are cases in which, again, I went to Virginia, and I decided to make some changes on death row, because it was run rather tightly. And so I wanted to loosen it up and make some changes. The AG was okay, but as we started, an inmate filed a lawsuit wanting to be placed in general population, a death row inmate. So the AG advised us to stop the changes that we were making, because the inmate and his attorneys may claim that those changes were only made because of their lawsuit. So we stopped and waited and waited. We won that lawsuit, so we resumed making the changes. Another death row inmate filed a conditions case, and we were told to stop again. And I said no. I said we're going to go forward. So we went forward. We made a lot of changes to Virginia's death row, not because it was deemed to be unconstitutional, but because the director wanted to operate a better and a different system. So now we're in litigation, a case called Porter, where they are alleging that the only reason those changes were made is because of their lawsuit. And they want a payday. And they want to get credit for the work that we're doing. That I find to be disingenuous, that I find to be troubling, and they have a cadre of attorneys, some pro bono and otherwise, that are working with them on this case today. So therein lies reason, I believe, for some of the frustration that we sense. I believe that we want some of the very same things that advocates want and that the offenders want. But there are different pathways that we have to go through to get things done. And often we're not given credit, like the two cases I just shared with you, when credit is due. And we're painted with a broad picture, which does not do a service for R2 and for correctional administrators as a whole. I think my time has expired. Thank you.
Thank you, Director Clarke. We will now hear from J. Kirk Brown, retired Assistant Attorney General, and after that we'll have a break before our question panel session. Please welcome Mr. Brown.
Nothing without my slides, apparently. Let me say as an introduction, this is going to come at you from a little different angle. I am not a correctional professional. I've had a lot of correctional professionals explain that to me. I am only a lawyer, but it was my fate only because I was assigned the responsibility in the late 1970s to be the only attorney representing in the Nebraska AG's office the Nebraska Department of Corrections. The last attorney with that responsibility ran to the AG and said, I can't stand it anymore. I'll do anything. And they moved this person on and said, well, everybody hates this. Let's give it to Brown. We only hired him to do another job nobody wanted to do, so I got it, and I found it fascinating. I can't explain why. I probably have mental health issues as well. But I found it a fascinating area to work in. I found it, the dynamics of trying to be an attorney in a politically driven system are very unique. And so I wanted, the first part of what I'm going to talk to you about today has to do with how does an attorney who wakes up one morning and you're in that situation deal with these things as an attorney. And then I want to talk with you a bit about why I think corrections over time. First, I was a trial attorney representing corrections. For 5 years, I was the head of the legal department for the Texas Department of Corrections, so I've kind of looked at it from both sides. Explain to you my understanding, or what I've come to believe, is the reason corrections is, as Harold said, is always the director of corrections or somebody in corrections is constantly named as a defendant in cases in which very often they have no control over what has made the other side angry. But anyway, with that background, let me say I will speak of this in terms of state government and state officials. I don't think many people, if you represent the city or a county or the federal government, will have any difficulty plugging your superstructure into the state structure. But I'll just say, to begin with, I'll start with the state structure. And I start with this, if I can find the right button. I haven't found the right. Voila. And that is, if you're an attorney, I think the first question you need to ask yourself when any piece of litigation hits your desk is, who is my client? It's a very clarifying and confusing question. In private litigation, it's not that tough. Your client is the person who's paying you to represent them. That achieves some level of focus right away. They've also chosen you. They walked in your door and handed you a check and said, please represent me. And they are also the individual who is solely able to make decisions about how to proceed with litigation or whether to settle litigation. That decision-making process is in the hands of your client. In government litigation, the answer to the question, who is my client, I found to be much more complex. First, as a diversion from the private practice model, the correctional administrator has not chosen their attorney. The law requires that they turn their legal actions over to the Attorney General for representation. They have no choice but to work with the Attorney General and the individual down the food chain that the Attorney General assigns to represent them. Second, the correctional attorney or administrator is not paying the attorney that is assigned to represent their case. The correctional administrator, the Attorney General, and the Assistant AG are all being paid by the same entity, this amorphous thing called the state. So that doesn't help us figure out who our client is either. Third, the various entities and individuals who make up the state may have conflicting policy and political objectives. I know this comes as a shock to you. The next time you hear some politician out making their normal stump speech at the Rotary Club, the odds are very good that they're going to have 2 points. One, they want to come down with a crushing fist on crime, and that'll excite some people. But they always finish with, and I'm going to lower your taxes. They never explain how it is both of those things are going to happen. But the crowd loves it, and they leave, and that's where we are. But the objectives of the elected official, who has a wholly legitimate role in our form of government, may be different than the, as Harold said, some of these things we would like to do. But can you do? And so there can be in the chain of command some conflicting interests, both policy-wise and political-wise. Now, in private practice, you can't ethically represent two people if they have conflicting interests. In government practice, if you don't remain focused on who your client is, it will happen to you all the time. So you've got to achieve some level of focus in your own mind, or you are going to be lost in this swamp forever. Fourth, the defendant correctional administrator very often does not make the final decisions with regard to the litigation you are representing them on in court. They may not make the final decisions on litigation strategy. They may not make the final decisions on settlement. So the private practice structure or vision of how litigation works doesn't work here either. So who is my client in correctional litigation if I am the attorney? Is it the defendant correctional administrator who's named in the lawsuit? Is it the elected attorney general who tells me what to do? Is it the elected governor who tells the defendant correctional administrator what to do? Or is it the elected legislature which passed the laws on behalf of the state, which may have prompted the alleged constitutional violations, and also which funds the governor, the correctional administrator, and the attorney general, and least importantly, me, as a government employee? Which one of those is my client? All of them, in my experience, will at one moment or another claim they are. Now, I just had to resolve this question. It drove me crazy from the time I started, and I don't know why. I never was in private practice, so I should be a creature of government practice, but it worried me. I resolved this question by looking at the piece of paper on the top of the file that came to my desk, and the name that appeared there struck me as my best guess as to who my client was. I knew it wasn't always going to turn out to be true, but I needed to cling to something. And so I would say, well, Harold Clarke, that'll do. Harold Clarke will be my client. Now, if I heard the governor's voice in litigation, I expected to hear that voice through my client, through the correctional administrator. They can have whatever conversations they want, but I wanted to ultimately have that information communicated to me by the named defendant. And that's how I proceeded, unless or until another elected official, who happened to also be my employer and at whose pleasure I served, directed me to involve other parties in the decision-making process. It could be somebody from the governor's office. It could be someone from the legislature that wants to at least have the attorney general's ear or my ear in this litigation. But the way I resolved what I've always found to be a perplexing problem of what is my client, because attorneys without clients are simply unemployed people. I always wanted to wrestle with this just to keep my own head straight, because I think it's something we don't think about in government practice maybe as often as we should. Okay. Once you resolve that, I think it's important that particularly if you work for government, you do have one other client. And that client has to be considered as you engage in litigation. And that player is the Constitution that forms our federal government, and to a lesser extent, the Constitution of the state government that employed me. Every elected office holder has taken an oath to uphold that document, uphold the Constitution. As an attorney, long before I was hired by the state, I have a sworn obligation to uphold the interests of both my client and the Constitution. So what does that result in as I work through a case? Number one, first of all, you've got to know what the Constitution expects of you. If you don't, if all you watch is CNN or Fox News to explain to you what the Constitution expects of you, you're going to be in damn poor shape, I think. But you need to know. And sometimes it will cheer you up. Sometimes it will not cheer you up. But you at least have to put a good deal of effort in understanding what does the Constitution expect of my defendant, my client. Number two, you have a duty to defend public policies and actions that can be legitimately argued to be constitutional. That doesn't mean you have to be sure, but it does mean you need to have an argument. My rule of thumb was, can you make this argument without looking at your shoes? If you're just up there going, yes, I think we ought to do this, that's probably not a good argument. But it doesn't mean you have to be right, but it does mean you have to have been able to construct some argument that your client's actions or the public policy that's being attacked is in fact constitutional. Number three, you also, in my judgment, have a duty to advise your client when, once you've studied the situation, if the public policy or public employee's action has resulted in a potential violation of the Constitution, that is something you need to share with your client. It may impact settlement. It may impact your litigation approach. It should. But it's something that is going to be uniquely in your knowledge. If you think you're the lawyer. If you think after study the Constitution has been violated, you have an affirmative obligation to share that with your client, even if your client has no desire to hear it whatsoever. And I've been in situations where I had a situation in Texas that didn't involve the Constitution, but I was talking to Texas. Their Department of Corrections actually has a board of directors appointed by the governor. And the chairman of the board of directors came to me and said they wanted to do something. And he gave it to me. I think it was my second day on the job. And I said, well, it was an area of the law I knew nothing about. And I said, let me look at it and I'll get back to you. And I called him the next day and I said, well, I've looked this all over and I don't think you can do that. And there was a pregnant pause at the other end of the line, and the gentleman at the other end of the line said to me, I don't have lawyers to tell me I can't do something. I have lawyers who, when I tell them what I want to do, they figure out how to make it happen. Our relationship never improved dramatically after that. In fact, I'll tell you another story with this same individual, which was, we were getting ready. We had a big conditions lawsuit. We were being, under a consent decree, we were being drug into a contempt hearing. And I was going down the long list of complaints we were being alleged to be in contempt of. I was general counsel then, so my client was somebody who was paying me. And we got down to this one list. It had been a long, ugly afternoon of just grinding through a list of 30 issues. And I said well, in fact, we were on a speakerphone, and the chairman of the board, who shall remain unnamed, and his administrative assistant were on the other end of the speakerphone. And I said, and here is the next issue, and we simply never got any funding to do this thing, which involved architectural changes, so it hasn't been done. And the voice on the other line is, well, we'll tell them we did it. And I thought that it was the administrative assistant who I had shared more than one beer with and had that kind of rise, or I guess you'd call it rise sense of humor. I thought it was him speaking. So speakerphone technology being as poor as it was in the 80s, I wasn't able to discern the voice. And I said, well, damn it, Andy, we aren't going to say that because that's a lie. And there was another pregnant pause, and then the voice came on and said, Mr. Brown, this is the chairman speaking. And if I tell you we're going to lie, God damn it, we're going to lie. At which point my director put his hand on my chest and just moved me away from the box. I think he thought he didn't have time to find another general counsel. And we went on. But my point is, I think you've got an obligation as an attorney to tell your client the truth. And if your client doesn't want to tell the truth, that's an entirely different problem. But you've got an obligation to educate them as to what the Constitution requires. Now, the next thing I want to talk about kind of relates to a lot of other things, but as I've watched correctional litigation for 30, 40 odd years, one of the reactions I would always get, I hear it in Harold's voice, is, why me? You know, why me? What did I do today to get my 400th lawsuit filed? But I think there is an answer to it, and I want to share you my thoughts on why that is. Why are correctional administrators so often the individuals named in litigation challenging our criminal justice system? And the answer, I believe, is because correctional administrators lack the one thing that protects every other segment of the American criminal justice system from legal attack. What is it that they lack? Answer, discretion. They lack discretion, and this is a legal term. Our whole system of government in this country hinges upon the courts respecting discretion. Now, what is discretion? It basically means that if the law gives a government actor a range of actions it may decide to take, the law is not likely to second guess a decision made within that range of options. So, if the law is passed and establishes a punishment for a crime of 10 to 50 years, the choice of a specific punishment between 10 years and 50 years represents an exercise of a trial judge's discretion. Now, who has discretion in government? The legislature is granted great discretion to determine what behavior will even be deemed a crime. I always told people when I was working death penalty, bear in mind, murder doesn't have to be a crime. And it isn't a crime until the legislature says it is. It may be bad manners, but it's not a crime until the legislature says it is. And that falls within their discretion. Next, they determine what punishment they believe would be appropriate for that crime. They determine the funding for our criminal justice system. They do all those things. And do you ever hear of a successful lawsuit challenging someone, challenging the legislature passes a bill and says, we're going to make the penalty for this crime 1,000 years and we're going to send you to prison, you'll never come back? No, you don't. And if you did, it would be a loser. So they're free to do this, and the courts respect that that is their role to make these choices. What about law enforcement? They've got a lot of discretion. First of all, they've got so much funding, they even get to decide which laws on the books they're going to enforce or emphasize. They get to decide which possible crimes they have to investigate with their limited resources. They decide who will be arrested and who will not. None of those decisions are subject to a serious legal challenge. Prosecutors. We've already had someone speak about prosecutors, but give some thought to what choices they are authorized to make. They decide who will be charged with crimes and who will not. Which crimes they will charge the people they're going to charge, what crimes they're going to charge them with. Which crimes, once they're charged, will be allowed to be plea bargained. Which crimes will be taken to trial. All of those decisions are given to the discretion of a prosecutor. And none of those decisions are vulnerable to a successful legal attack if you don't like the decision they've made. Judges are granted discretion. For example, with what specific punishments may be imposed for a crime. You will see excessive sentence appeals, but the first thing the court will tell you is the appellate court will say, well, we exercise, we have to respect the discretion of the trial judge, and they very seldom will reverse a sentence unless they find that the sentence was imposed outside of the ranges they established, which is clearly bad because that isn't even an authorized sentence. So judges have a lot of discretion. Parole authorities have discretion. They get to decide who will be granted parole and who will not. That's the authority the law gives them, or the decision the law gives them. So let's compare those players from the front end of the criminal justice system to the back end. Let's compare them with correctional administrators, who in my opinion have very little discretion. They don't choose who will be ordered to be incarcerated. They don't choose how long the criminal must be incarcerated. They don't choose when the prisoner must be released. And they do not choose the funding or facilities the state provides them to house, protect, and care for the criminals they are ordered to hold. They don't have any discretion. Oh, they have a discretion, but not the type of discretion that the other players in the criminal justice system have. And that produces what, for want of a snappy title, I call a legal double whammy for the correctional administrator. First, if a government actor has no discretion, they are much more exposed to being accused of failing to do what they are legally required to do. The less discretion you have, the more likely that argument is to be made successfully against you. Second, it is only when a citizen is incarcerated at that moment, not before, that the abstract public policy decisions that have been made by the legislature primarily, perhaps by a governor, but those abstract public policy decisions finally and directly impact a specific individual. That individual in cuffs being walked through the wire into the prison. That's the moment when all those talks about being hard on crime and all of that, or not raising your taxes or running government like a business, all of that is hyperbole, but it all comes to ground the minute a citizen of this country walks through the prison gate. Because they also happen to be, as Laurie explained earlier, they also happen to be an individual who has enforceable constitutional rights. So now, once they're inside the wire, you have an individual being directly impacted by public policy, and that individual has certain constitutional rights that they don't lose by virtue of their incarceration that are enforceable. So you have very limited discretion, or for this sake, no discretion in how you handle them. And they finally have rights to challenge all all this abstract public policy that everybody else has been holding forth about. So why me? That's the reason. You're vulnerable. The most vulnerable link in the entire chain of the criminal justice system of this country, in my judgment, are correctional administrators. You have the least discretion, in many respects the most responsibility, and that's where the attack will come, because that's the only opportunity or the best strategic opportunity to attack the criminal justice system if you are concerned that the criminal justice system at any point in the whole thing has gone awry. By attacking you correctional administrator, plaintiffs often seek to obtain leverage indirectly against public policy makers they simply cannot successfully attack otherwise. They can't sue the legislature because they want to send somebody to prison for 3 lifetimes after their 3rd felony. You can't sue on that. That's 99.9% of the time it's going to be laughed out of court. But once you send someone to prison for 3 lifetimes, that individual can challenge it. They couldn't challenge it before because they weren't going to prison for 3 lifetimes. But why are you attacking the correctional person? Because they decided we wanted to have a 3 strikes program? No. They're attacking the correctional administrator because, and only because, they are legally vulnerable. So I used to tell my clients, and I would tell them this knowing how fruitless it is, don't take it personal. Well, how do you not take it personal? First of all, I recognize my name. My mother taught me to read and write, and I'll be doggone, that looks like my name. And then I read a couple pages, and they didn't say a single nice thing about me, and I stopped reading it. It was just annoying. I know it's impossible, but what I'm trying to say, what I'm trying to communicate is try to understand why you? Why not the parole board? Why not the legislature? Why not the governor? Why not the judges that send these people to? The answer is they aren't as vulnerable as you are. It's not good news, but it may help you keep from taking it as personally as we all instinctively would do. I mean, Laurie was telling the story, when I moved back to Nebraska, I bought a house. And I didn't think anything about it. And we're getting ready to close on the house. My children are standing on the curb. And we get a call from the title company and say, well, we can't close on this house. You've got 5 lawsuits pending against you in Texas. And I went, 5? They obviously can't count. But those things held up the closing. I had to get a letter from the Texas Attorney General saying that they were not likely to result in any personal liability on my part, and I had to put off the closing on my house for a week. And I took that personal. So those are the realities that I just think you need to understand where you are in the system. It's where you are in the system, not who you are, that causes you to be the focus of so much attention. So, having messed around with this for 40 years, what advice can I give correctional administrators or lawyers that are representing correctional administrators? And this is going to be harsh advice, in a way. Number 1, do what public policy makers tell you to do. Do it. Follow public policy, whether public policy makers, with whatever public policy makers give you to do it. Do the best you can with what you've got, but realize what you've got. Be professional and creative in what you are, with what you are given. That's your professional, that's where the professionalism of corrections comes in. You get 80% of what you want and you try and do 100% of what you need to do with it. But that's where the, in my experience, where the true professional comes in. However, do not, I recommend, not attempt to make public policy decisions harsher or better or fairer than that public policy decision is. So, my advice, and I've given this advice, if you can't adequately house your prisoners within the facilities you've been given, just don't. Don't adequately house them. If you can't keep your prisoners safe, don't keep them safe. If you can't provide your prisoners with adequate medical services, don't. It's simple. If you think a statute or a rule or a policy seems unfair or even unconstitutional, still enforce it exactly as it's been given to you. I've seen too many correctional professionals risk or ruin their careers and risk their personal finances trying to do the right thing and attempt to make up for the failures of public policymakers. I don't know how many times I've told you, I've seen more corrections people get blown up trying to be nice than I have ever seen people get blown up trying to be mean. You wouldn't think so. That's not how you see it in the movies. I had a good friend of mine, came to be a good friend down in Texas. He was a top-level executive, and we had a personnel matter that had to be heard, and it was so hot that they pulled out the division head who would have normally heard it because he was involved, and they assigned it to my friend John, and he'd never done a disciplinary thing before. We were all a new administration, and he walked into my office, first time I'd really met him, and he said, "I've got our disciplinary procedures here." And he was a career military guy, and he said, "These are a mess. These aren't fair. I mean, they're just, first of all, they're just don't make any sense. And two, I don't think they're fair to the guy I've got to have a hearing on. So what should I do? How should I change them?" And I thought about it for a minute, and I said, "John, don't change a thing." And we had a long talk. He says, "Well, that's not going to be fair to this guy." And I said, "My best advice is to do it exactly the way the rules say to do it." And John took my advice. The guy was fired, sued us in federal court, and a judge who had grown to hate the Texas Department of Corrections and anybody receiving a paycheck from them was a lying sack of something. And we went to trial on that case in front of Judge Justice. I'll never get over that. And he entered a $400,000 judgment against the guy who had taken my advice. And it was troubling. John took it a little personal because it was a personal judgment. I took it a little personal because he was the only guy I knew that had ever followed my legal advice. And it took us 18 months to go to the Fifth Circuit and have that case reversed, and they reversed it because they said he did what the department told him to do. He can't be personally liable for doing what he was told to do. The institution may be liable for having bad rules. But even one of the concurrents said if he'd have done anything else, you go beyond the pages of that document even to try and make it fair, and you're on your own. And if we decide we don't think you made it fair enough, we will come down on you like a ton of brooks. The moral of that story is, I just take it away. Do what you have to do with what you've got. But if you try to be nice, you're on your own and very difficult to defend. I think with that, bear in mind, making up for public policy failures is not your job. And just as a sidelight from your lawyer, you're not authorized to do it. So if you try to make up for it, you may be personally exposed to liability. And that, when I think you're my client and my only client, is the last thing I want to lead you into. So I'll just say that I believe the job correctional people do is one of the most misunderstood and thankless jobs in the American correctional system. And I also think it's one of the most important and surely one of the most complex responsibilities that any society assigns anybody. I always like to say, I don't think it makes any difference whether you want to run a communist country or a libertarian country or whatever philosophy of government you want to do. In the end, I would be willing to bet, and I am not a gambling man, the correctional corner is the corner that isn't going to lay flat. You can get everything else smoothed out, but when it gets to what do you do with the most disruptive people in your society, it just is a pain. It's a pain whether you want to be nice. It's a pain if you want to be mean. But it's an incredibly important thing in every society to do, and I have a world of respect for the people who take it on doing it. Thank you.
Thank you, Kirk. Ladies and gentlemen, we're going to call the meeting back to session here. I would ask that you please remember before you depart, if you would please, there's an evaluation form that we would ask that you fill out for UNO School of Criminology and Criminal Justice. Please take the time to do that. It's important. It will affect future presentations. We're going to pick up now with a panel discussion, but I want to point out this is the point in time where questions will be welcome from the audience. We have a significant off-site audience, so if questions are asked from the audience, I'm going to repeat them so we make sure that the off-site audience can hear the questions as well. If you have a question for any of our panelists, please address them by name so we know who the question is being asked of. But with that, several of you had additional comments. This is a great time to do it. I just ask you to open the questions as they come. Thank you.
Hi, good morning. Yep.
I'll ask a question. I don't know that it necessarily fits precisely within the litigation area. Like,
We'll tell you.
just throw it out there. This question is formed by 40 years of bias serving with the Army and the Army Criminal Justice Corrections and Parole Pharmacy System. The Army came within 2 weeks of executing Ronald Gray in 2008. He raped and murdered, sodomized, and killed several women around Fort Bragg, North Carolina. He was sentenced to death in 1987 or 1988. He went to the disciplinary barracks there. He's still on death row, to use that term, almost 30 years later. This case has been in multitudes of appeals. It's been to the Supreme Court at least twice and denied, served twice, and come back. 2008, 2 weeks away, a federal district court judge stayed the execution and remained in a stay for nearly 8 more years. Was released from the stay about a year ago, only 2 exact days. So it's now back in active work, and I don't know what's going on with the execution. But sort of within the framework of this whole litigation process, it doesn't seem like there are many limits, to someone who's a non-lawyer or non-judge. Limits on what can be litigated, the amount of times it can be litigated, how frequently it can be re-litigated. Am I wrong? My perspective.
To the off-site audience, it was a long question. It basically raised the question about a death penalty case in the military that has been pending for many years, and a question of what the limitations are affecting that. And it's open to the panel.
I know Kirk has incredible expertise on those topics.
My first reaction, aside from my life in corrections, I spent 30 plus years doing Nebraska's death penalty litigation. But having done other kinds of litigation, I would say
that death penalty litigation is truly unique in that regard. And it's unique, if nothing else, because of the lack of will of jurists to enforce it. It's very easy to say, well, let's go back and look. And it's very hard to look a defendant in the eye and say, no, you've had all the process. So I think it would be a mistake to judge the criminal justice system as a whole based on a death penalty case, because there is a whole emotional dynamic that goes with them that I think legitimately raises the question, is there ever going to be an end to this? I don't think that's good. I don't think it's good for the image of the system, but I don't think it's an indictment of the entire, I think it's very unique to that particular class, that type of delay. We've got somebody on death row here that I think was on death row shortly after I was licensed to practice law in 1973. He's still there. And I always joked with people when I was doing this, I'll be in my office and have a heart attack and die, and he'll be alive because he's being watched closer than I was, and he'll have medical care within 5 minutes, and I'll lay there till somebody smells me. I'll just lay there. But I just don't think you can compare that environment with any, it's just utterly unique. And I think it's not driven by logic, but I think it's driven by emotion.
But I also added it's also unique to states as well, because in the Commonwealth of Virginia, the average stay for someone on death row is 7 years before execution, because they just choose to prosecute those cases.
Yeah, I would concur with what my fellow panelists said, and I think that this very issue was very present in Nebraska's most recent statewide dialogue about the death penalty referendum that faced our state at the last statewide election. And I think opponents of the death penalty and capital punishment, like the ACLU and myself, continue to make the case that the death penalty is broken and it doesn't provide justice for those impacted, and that's why we need to look at other alternatives. But I think the courts have been very clear, and I agree with Kirk, death is different for a variety of reasons, practically, politically, and legally.
Oh, for example, politically, we had, hypothetically, you had a governor involved in getting the death penalty reinstated after the legislature repealed it. But that same governor has taken no steps to make the death penalty enforceable in this state because we lack the drugs to carry out the execution. I can't figure out the logic of that, but that is the reality. We have the death penalty, but the same individual that drove the reinstatement of the death penalty has taken no actions administratively to make it enforceable, practically. So whether that's just a purely political, I agree. The political element of this has to a great extent poisoned the judicial element of it. And it's a mess. No matter which side you're on, it's a mess.
I recognize it from your slides, the judicial discretion and the policy issues, politics involved. So thank you all for that.
Director Clarke, you had a point you were trying to make earlier, and you wanted to elucidate on that a bit more during the question and answer session. I think it was about Red Onion. But...
Yes, it was about the HBO video that some of you may have seen about Red Onion, and I slightly talked about that a little bit earlier in my presentation. But Red Onion was that facility I highlighted that was designated as a supermax institution initially. Well, as a result of the work that we did at Red Onion, a film company out of New York City contacted the Secretary of Public Safety and asked to do a documentary to chronicle the good works that we did at Red Onion. So permission was given, and I was interviewed along with the clinicians responsible for putting the programs together and many others, and we waited for a couple of years for this to be completed. Well, once it was completed, HBO bought the documentary, and it got reworked. And so all of the work that was done The school wasn't shown in the documentary. The programming wasn't shown in the documentary. They just showed a supermax in operation. And that really upset the department and all the folks that went in, that worked hard in helping to win that award. None of that was shown in that documentary. So my point was going to be that if you have seen that documentary, it is not representative of what that institution stands for today, but it's what some advocates, to include folks from HBO, wanted to portray, to influence the public in a manner that they chose.
So it was less a documentary than an editorial.
Exactly. Mm-hmm.
I would share one other story with you. I was going, but Bob held up his hand. And this is the other side of the coin. This is a time when a client didn't take my legal advice to just do what the Constitution told them to do. When I moved to Texas and took the position down there, basically we had an administration that had been in less than 12 months when I was hired. But basically the Texas Department of Corrections was being run by the gangs. They had done away with prisoner guards, because that's another story, but they had used prisoner guards. Then when they did away with using prisoner guards, they didn't have people employed to take their place. And I shocked me. It takes 7.4 FTE to replace one 24/7 prisoner guard, and we just didn't have the bodies. And since nothing in nature likes a vacuum, the gangs came in and just basically took over the prison system. The day I went down to interview for my job, that meeting of 2 hours was interrupted 3 times to inform the director and the chairman of the board that there had been yet another homicide in the system. I mean, we were losing people right and left. And the director at that time, a gentleman by the name of Lane McConaughey, just was frantic almost, and called a big meeting and said, I got a plan. I want to do this. I've got pretty good gang intelligence. I've had them harden a cell block in one of the units. I want to go in at midnight tomorrow night and pull these gangbangers out and lock them down 23 hours a day. What do you think? And I said, well, you know, we're going to seriously reduce their level. They probably need a hearing, blah, 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 blah. And he said, I'll never forget it. He looked at me and he said, look, I've got an obligation to have as many prisoners alive at 9 o'clock when we count as I had at 7 o'clock when we counted. And I'm not, and he said, I don't care. We're going to lock these guys down. And he did. And we went 18 months in a system with over 60,000 prisoners. We went 18 months before we had another homicide in that system. And I kept waiting for the lawsuit to come, and it never did. And the backstory I was given was because Texas was under about 18 consent decrees, and we were in constant litigation over that. The attorneys that represented the inmates and the cadre of inmates that they talked with the most said the inmates came to us and said, don't challenge this because it's safer in here now. And so no one ever challenged it. I don't know that we would have withstood the challenge, but I always had a lot of admiration for a client that would say, I'm sorry about the Constitution. I got to stop these murders. So some people took my advice and did well. Some people took my advice, only did well in the long term. Other people ignored me and did very well very quickly. So.
I was just going to see if Judge Smith can talk about discretion in sentencing and how that fits in the discussion about that level of discretion you have and the fact that it's made and consideration being made in
the question is to the judge, it concerns discretion in sentencing and how the court weighs that in judging the sentence.
Well, I think we all have concerns about equal protection. And one thing that makes us uncomfortable is when two offenders who have done virtually the same thing go in front of two different judges and get very different sentences. That was the concern that was behind the federal sentencing guidelines. When I became a federal judge at the end of 2001, the guidelines had been in force for many years. They were developed over a lengthy period of time by people having a lot of expertise, and I have great respect for the guidelines. Those of you who are not familiar with the guidelines would want to know that it's a grid where there is one axis representing the level of the offense, the seriousness of the offense, and the other axis is the defendant's criminal history, going up to category 6. Then we take those two axes and find a little box that gives us the sentencing range. Now, at the time I became a judge, those guidelines were called guidelines, but in fact, it was virtually impossible to deviate from the guidelines without being reversed. I tried one time and was told, no, the guidelines are really not guidelines, they're mandatory and you have to sentence inside the guidelines. That changed in 2005 with the U.S. versus Booker decision that came down from the U.S. Supreme Court saying the guidelines are in fact guidelines. That's where we start when trying to decide where to sentence. And then we look at other sentencing factors that include logical things such as general deterrence, specific deterrence, the defendant's danger to society, the need to avoid unwarranted sentencing disparities, the defendant's history and characteristics, things of that nature. The sentencing statute also refers to the defendant's need for rehabilitation, but the Supreme Court has said prisons don't rehabilitate anybody, and so you can't send somebody to prison for rehabilitation or consider that as one of the purposes for sending someone to prison because they just don't rehabilitate. Now, I've seen people that I think had been rehabilitated in prison, or they could have fooled me, and I've had many people come back and tell me that they're grateful to me for having sent them to prison because it was the best thing that ever happened to them. They got clean and sober and got into some great programs and are now out and supporting their family and leading a good, clean, law-abiding life. But regardless, the U.S. Supreme Court says prisons don't rehabilitate. So when I began sentencing, I was getting a little pushback from some of the people in the Federal Public Defender's Office and in the private defense panel because my sentencing philosophy was different from some of the other judges. We had a couple of judges who would be very lenient once the guidelines were considered advisory and not mandatory. And if a defendant had children, the defendant was not going to go to prison. If the defendant had a difficult upbringing, a sad story, the defendant was not going to go to prison. And I could tell that these defense lawyers were getting very frustrated with my sentencing. So I actually posted online on the court's website arguments that will work if you are defending a criminal who is going to be sentenced in my court. Arguments that will not work if you are sentencing someone in my court. And the lawyers actually read those, and it changed the sentencing arguments pretty dramatically. Instead of showing me videos about the weeping mother who didn't want her son to go to prison, they focused on things such as post-defense rehabilitation that I do consider and I can consider now. Until a few years ago, again, the Supreme Court said, oh, you're not supposed to consider that because they're just faking it. You know, if they've become clean and sober and they got a job and they are following all the rules on pretrial release, they're just faking it to get an easier sentence. And I say, no, if they can make those changes, that's a pretty good indicator that they're getting on on the right track, and I'm going to take that into consideration. So if anybody wants to see my sentencing philosophy online, you can see it on the Federal District Court's website. And I hope that responds to your question. Okay.
I've got a follow-up question on that, more on the legislators, and I actually don't know this. Is there, a lot of the solutions are legislative, right? Do you sense in the conversation that there's sort of an understanding of even the balance between general and specific deterrence, rehabilitation, justice, retribution, whatever? Is there a conversation at that level among the legislators, or is it just kind of you come in and there's a number there and people say it's too high or too low?
The question is concerning sentencing from the perspective of a legislature and the factors that are considered in drafting legislation.
I suppose that's me.
It's you.
Well, I can speak to my experience in the legislature. For the most part, our elected representatives in Nebraska are not attorneys, are not criminologists, are not correctional officials. They come from a diverse set of backgrounds, representing a diverse set of perspectives, but a lot of ag professionals, a lot of business people, a lot of bankers. And so I venture to say that until they got to the legislature, they didn't think a lot about the very kinds of questions that you presented. I had a chance to think about these issues a bit during my law school training, taking both criminal law, criminal procedure, death penalty, criminal sanctions, and had a great deal of time to think about the theoretical underpinnings of a peniological system. In my experience, where those questions were most present and most debated were in the context of the death penalty debates, about whether or not the death penalty was the deterrent generally, specifically, etc. In terms of other criminal sanctions, establishing new crimes, enhancing penalties, and I was never a member of the Judiciary Committee, which has jurisdiction over the majority of the criminal justice policy, so I can't speak to the inner workings of that. But from the floor perspective, I think that those considerations, values, issues, theories, and debates rarely entered into legislators' minds or decisions when deciding how to cast their votes on those questions. Again, everybody decides how to cast their vote differently, but it definitely wasn't part of the floor debate for the most part outside of the death penalty. It probably should be. That would be welcome.
If I may add to that, it seems to me from my perspective that legislators rely on their own knowledge that they brought with them or what the loudest voices are saying to them. But I have not ever been called in by a legislator to seek my opinion on rehabilitation. And I'm the longest serving director of corrections in the country with 28 years in this position now, and I've never been called in by a legislator and asked whether I thought even capital punishment was a deterrent or if rehab is working or not working.
If I could just add, unfortunately, I've learned working more closely in Nebraska with various legislators, and we have Brian Swan was here, works very much with people. I don't think that we as a criminology criminal justice program are brought in hardly at all. And so we are attempting to make more and more proactive efforts to share information. And we do have 2 legislatively funded institutes within the school. Certainly those are counted on. But when pending discussion on mandatory minimums, compassionate release discussion that might be going on, you would think that the academic scientific side would be a natural piece of communication, and just what Commissioner Clarke is saying, too often I think various pieces have been left out as resources, and so it's incumbent upon us to be proactive in sharing what we do know to help educate legislators, knowing they're not criminologists, but often called upon as part of the decision-making process. So it's a very interesting system.
And don't forget that the legislative process, for the most part, is also very reactive, right? Something bad happened in a community, and then that community speaks through their elected representatives to try and prevent that from happening in the future. And that's usually the impetus or the origin for somebody coming forward and saying, let's establish a new crime or let's enhance a penalty here, which is very understandable, right? Because that community's really hurting, and we don't want bad things to happen again. But the loudest voices on criminal justice issues are from the Prosecutors Association, to a lesser degree, but somewhat, from law enforcement agencies, and then from, impacted communities or particularly victims. We rarely have a chance to engage from the academic perspective or to be informed by that science and research and data. Now, people do try and bring that in through their other advocacy, and individual legislators, I think, do try and bring that in. But for the most part, there's not a lobby of criminologists that are there all day, every day, where the real deals happen, where the real discussions happen, to say, oh, but you're forgetting about that footnote on that critical study. Like, that's just not a part of how the process works. I do think in some of the recent reform efforts that have been undertaken in Nebraska, there's been a greater look at some of those questions, whether it's through the CSG, the Council for State Government's Justice Reinvestment Initiative, whether it's working with the Vera Institute to do a deep dive and a hard look at the data surrounding our use of solitary, restricted housing, segregation, whichever you want to call it. And I think that's good. I think it's really educating policymakers about the impacts of their decision, allowing them an opportunity to look at models from other states, so it's not guesswork, but it's a slow process. I think that the legislative process is always improved by more voices.
But I should also add as well that while I've not been called in, I have taken the initiative, the department has, to identify areas of need. And we have presented those to our boss's governor's office, which ends up in the legislature. And we have received support after having done so on a number of occasions.
I guess the only observation I would make, and I have not been as deeply involved as either of the people on either side of me, but what I have observed from afar was, particularly with criminal justice issues and particularly with sentencing issues, the scheme is to, when you pass a bill, you're supposed to address the fiscal impact of that bill. And I have seen time and time again where, for whatever reasons, I'm not making a value. If you want to put drug dealers away for 80 years, that's fine. If you want to put them away for 10, I'm not lobbying that. But there is clearly an overhead to putting people in prison longer. And I never hear that. I've never heard it discussed. And the fact of the matter is, in the end, if you put longer sentences, you don't even turn your beds. And it's all about beds in prison. How many beds do you have, and how many people do you have to lay down? And the tougher you get on crime, the longer sentences get. You don't turn those beds. You've got somebody sitting there for a long time, and there's a fiscal impact, because when the new guy shows up to serve 3 years, there's nowhere for them to lay down because somebody's doing 40. And that is something it's not impossible to reduce that to numbers. But I don't ever hear that being discussed. I don't even know if it's really offered in any realistic sense.
We have a question in the back.
Speaking of money, I was wondering if you all had any thoughts, or anybody on the panel, about preventing some of these lawsuits in the first place. I think, I'm in this field, I work in it all the time with jurisdictions who are sued. It's very expensive. It's expensive for the state or jurisdiction. Federal monitors are very expensive. And so it ends up being a real taxpayer burden. So do you have any thoughts on maybe just preventing it from happening in the first place?
For the wider audience, the question was, do any members of the panel or all of you have some thoughts on how to reduce prison litigation by proactive means?
I can try. Take a first swing at it, and I know you'll help me out, hopefully. But I don't think you'll probably ever eliminate prison litigation in any system for a variety of different reasons, some of which have already been talked about in our earlier comments. But when it comes to, I think the more significant cases, like our case, thinking changes condition-wide, system-wide, I think that there is a lot that a state can do for, litigation insurance, for lack of a better term. Our organization was crystal clear going back years, saying, unless you do X, Y, or Z to fix the system, and we'll do do the hard work hand in glove to the best of our ability to help you do so, we will have to pursue litigation. And we wrote op-eds and we wrote reports and we testified at hearings and we organized advocacy efforts. And, and that made a positive difference to a certain degree, but then at a certain point the political will dried up. And so, legislators and the governor can ignore what's in the newspaper, and they can ignore what we say at a hearing. What they can't ignore is the federal court. And so I think that, we made every effort possible to exhaust our other remedies, and that this was not a decision taken lightly to move forward. But it's a critical part of the effort to bring change and to infuse resources into the system and have better outcomes for everybody. We'd love nothing more than for our case to be mooted out, to have robust changes and reforms and investments made, to have robust settlement discussions with the state to ensure that we can get some consensus together moving forward. It's always better, it's more certain, it's less costly, it's less lengthy than civil rights litigation tends to be. So I think in some ways everybody wins in those alternatives. But our system, our democratic system, is set up to resolve conflicts in this very way. That when the other branches of government fail to act or act across the bounds of our Constitution, then the courts step in to rebalance and to protect individual rights. So I don't think you'll ever eliminate prison litigation, but I do think that there are things that systems can and should do to prevent significant judgments in significant cases.
Clarke? While serving as a director in Nebraska, in the 1990s, we were crowded. And I was able to get increased capacity by convincing the legislature that we were crowded. And I recall saying expressly that absent increased capacity, we were going to have litigation. And that got their attention. And I remember working with Senator Werbine and others, and that's how Tecumseh came about. That institution was the result of those conversations. But I believe that one of our major responsibilities in corrections as administrators is to train. And so we train our staff. We train our staff on legal precedents. We train our staff on the constitutional requirements and a number of other areas. And all that's done in part to prevent litigation as well. But I personally believe that it can be prevented if the sides will just choose to work together to address some of these issues. But again, I agree that there are going to be times that we just can't agree, and we're going to have to go and have our differences are resolved by a court of law.
I think there's some people have accused me of being cynical, but I think there's also a political dynamic here. And the political dynamic is, if you're a governor, for example, you don't want to spend money on prisons. That's not going to get you any applause at the Rotary Club. And if you took affirmative actions, Danielle mentioned, this isn't something you put on your flyer, that I've tried to reform the correctional system. The only way to survive that politically is to be able to turn to the people at the Rotary Club out in Alliance and say, the courts made me do it. And I think some people covet the shelter of being told they have to, because then it's not their decision to run government responsibly. And it doesn't make sense to me, but I've seen it often enough in enough environments where, well, then we can all yell about an overreaching judiciary or these damn attorneys that represent these whining prisoners, whereas they wouldn't do it. But now they have the excuse, no matter how much it costs, and the costs are huge, but cost and political success don't necessarily mix in the same malt glass all the time. So I think sometimes there's an unconscious, if not a conscious decision, is I'm not going to fix this until the court tells me to, because then it won't be my fault. I had to spend the money to fix it. Ron?
Well, as a judge, of course, I don't express opinions on this type of thing. But in the 90s, as a lawyer, I did write some articles on the topic, and one is in the Nebraska Law Review, volume 76, 1997. This was why Nebraska needs prison litigation reform, with some suggestions about how prison litigation could be reduced in Nebraska, and that was republished with a new edition in the Nebraska Lawyer magazine shortly after that. And then I wrote a monograph for the Nebraska Association of Attorneys General in May of 1994 on managing the defense of inmate litigation that again included some suggestions about ways to, so I have no opinions as a judge. I did as a lawyer. If you want to read them, you
can't take it back.
Can't take it back. It's out there.
You know, I just one last comment on that I think it complicates the ability to come together across the political spectrum to a certain degree today is the term limits dynamic that is now in Nebraska and present. When you look to state leaders coming together in the 80s and 90s, as the other panelists have talked about, hey, that's so hopeful to know that Nebraska was once leading, and when we ran afoul, we came together and we fixed it and we got back on track. So there's good models right here that we can look at. But you also had folks like Senator Burbine and others who, you know, had served a long time and were a very well-known quantity to their communities and their constituents who sent them there, and rarely faced serious challengers because they did a good job and were thoughtful and hardworking, even if they didn't always agree with them. But now that you have a term limits dynamic and people are only looking to survive re-election one time, there's even less political incentive and political will to lead on these really hard issues, and I think that's something that complicates
We have
today's
a question
politics.
in the back and then the lady in front. Yeah.
So speaking of political, I want to talk about sanctuary cities. And that's coming up particularly with Jeff Sessions, or Attorney General Jeff Sessions, particular cities and stating that they're going to enforce some type of policy. And you know, it's such a political competition. We're looking at federal versus state, your perspective in terms of incarceration, including policies, particularly the rights of individuals who are not U.S. citizens, depending on your terminology, you might call them assigned immigrants or merely undocumented immigrants. So I'd like to know from the panel what you deem the issues are, what an important issue that you guys like to pick out on sanctuary cities, and possible solutions, particularly getting, this part of the church.
If I could, I don't know that question really addresses what this panel is prepared to discuss. I'm sure these folks might be able to address it after the session, but we have limited time, and I'd like to focus on prison litigation and jail litigation.
Yeah, there's at least one intersection I think that might have a good tie-in to this discussion, and that's ICE detainers for pretrial detainees in the immigrant population. And I think this is an issue that is even broader than the sanctuary cities debate that's presently before us, but that local law enforcement have struggled with all across Nebraska and all across this country. And courts have been very clear about the constitutional rights of aspiring immigrants or undocumented individuals in our communities about what can happen during that time when they've been contacted by law enforcement, but before immigration might come to enforce the immigration violations or issues. And there's an incredible liability there for local law enforcement and for local communities to hold people on ICE detainers as, brought up to bear through litigation primarily surrounding the Fifth Amendment. But I think that that's a piece that does tie into prison litigation to a certain degree. And we've seen cases work their way up through the 8th Circuit. Right here, the ACLU worked on a case called the Mendoza case where it was challenging ICE detainers and some of those kinds of issues. But it's not going away. And there are intersections with criminal law and immigration law and law enforcement, which are all at the heart of those sanctuary city issues, are going to be a part of additional litigation moving forward, I predict.
We have a question from this lady here.
Yeah, I have a few questions, but maybe the biggest one. Can anyone talk about how the growth and expansion of private prisons has affected prison litigation and the role that their lobbying corporations might play in prison or jail litigation?
The question was about the role that private prisons may have in prison and jail litigation, and we have 2 minutes remaining in our time.
Well, I'll just toss in and say when I was in Texas, because they had such a backlog of prisoners backed up in the county jails that they couldn't take into the correctional system because they had litigated population caps, they went on a humongous building program. And the decision was made that they couldn't create all the beds they wanted without going with private prisons. And they had 2 different private operations. But I don't know that it ever impacted prison litigation, because in the end, if litigation arose at one of those units, it still went to the AG's office. And you didn't have arguably any more people locked up than you did before. They were just now in a whack-and-hut prison instead of the Harris County Jail. But I don't know that it increased the cost. I would debate for a long time whether that's the way anybody ought to go, but that's an entirely different question. But I don't think it impacted litigation as long as they were supervised and maintained the standards that were part of their contract.
Under our agenda at this point in time, we're going to ask Judge Smithcamp if she would please sum up and make any further comments.
What, 2 minutes?
Actually, you have 20 minutes, and if there's time left at the end, we can have more.
As I was saying.
And I was a trial lawyer too long to shut down a federal judge. So you take all the time you want.
I will not take 20 minutes, but I just marked down a few notes. Can everybody hear? Should I get closer? Okay. I wrote down a few notes as the other panelists were talking, and I thoroughly enjoyed each of the presentations and learned a lot from the presentations. One little story I want to share is about Judge Warren Urbaum, who became a federal judge in the District of Nebraska in 1970. And he told me that when he became a federal judge, the Nebraska State Penitentiary was segregated based on race. If anybody saw the old penitentiary, it had a castle-like structure in the middle where the warden and his family actually lived. And then it had an east wing and a west wing. And the African-American inmates were in one wing and the white inmates were in another wing. Well, in 1968, the U.S. Supreme Court had said prisons aren't supposed to be segregated based on race. And a case came before Judge Urbaum, and he ordered that the state penitentiary be desegregated. Well, he says that he was told by the people who were the administrators of the penitentiary at that time that he would have blood on his hands, that there would be dead bodies lying in the corridors, and blood would be running down the galleries of that penitentiary, and it would be all his fault. Later, after the desegregation occurred, there were no killings, there were no injuries. It actually went very peacefully. And Judge Urbaum told me initially he felt pretty smug about that. And then later, as he matured and he understood a little bit more about the correction system, he said he just felt extremely lucky. Now, that shows a degree of humility on the part of Judge Urbaum. I remember another incident in the 1980s when Chief Justice Warren Burger came back to Omaha to give a speech. And he considered himself to be an expert on how to run prison systems, although I don't believe he ever had any experience in running prison systems. So he came back to give a lecture about how prison systems should be run, and he called that lecture Factories with Fences Around Them, kind of the Auburn model. Well, during that presentation and after the presentation, the Chief Justice, I believe, showed a degree of arrogance that was not attractive. And I don't think that the people working for the prison systems really learned a great deal from the Chief Justice about how to run their systems. I think his time would have been better spent listening to people like Harold Clarke and Bob Houston about how to run a prison system, and then taking that information back with him and sharing it with his fellow federal judges. When I first went to what they call baby judges school, and that's what they call it, everybody calls it that, the first stage of baby judges school for all of the federal judges who are coming in as new judges is at a location where the judges can go out to a prison within the Bureau of Prisons and take a tour. Then the second half is back in D.C. And they do this because the great majority of people becoming federal judges have never stepped foot inside a prison. They have come from backgrounds generally in private practice doing civil work, usually insurance defense work, because that's the most lucrative, and that way they can make large contributions to political candidates who then appoint federal judges. So it's unusual for somebody as a federal judge to have any experience whatsoever in corrections. They get their experience by watching Cool Hand Luke and the Shawshank Redemption, and that's their idea of what goes on inside a prison. But then after they're on the bench and they start sentencing people, federal judges tend to believe that they're experts in everything. They're supposed to be jacks of all trades. We handle all kinds of cases, civil and criminal, but there is something of an ego that goes along with the position that can cause an individual to believe that he or she is an expert. And I mention the issue of ego because I think that this, I hope, will help kind of tie together things we've been talking about today. I started off giving history, so I'm going to go back a little farther in history, all the way to Aristotle, who was really the first philosopher to talk about ethics and what it means to be an ethical person. And Aristotle said an ethical person, or someone who is trying to persuade other people to believe that he's an ethical person or she's an ethical person, should have three basic characteristics. The person should have competence, should be good at what he or she is offering to do. And that ties in with what Harold Clarke was talking about in training people and making sure that they have the competence to do what they're supposed to do in the correctional system. It ties into the ACA accreditation and best practices. So competence is number one in being an ethical person. Then empathy is number two. And it doesn't mean just being sympathetic or having pity for somebody and feeling sorry that they had a bad childhood. Empathy means listening to other people, caring about what other people think, caring about how your actions affect other people, and being open to the idea of changing your point of view after you've heard from other people. That's what Aristotle meant by empathy. And then the last thing Aristotle said you should have to be perceived as an ethical person is good character. And he said good character may differ a little bit depending upon where you are and the time and place. But you are perceived to be a person of good character if you are upholding the highest values of your community, embracing and embodying those values in your actions. So I think part of what we're doing here today is trying to develop an ethical approach to corrections where we emphasize competence and we are wanting to learn from each other by being here. We are emphasizing empathy by listening to each other and trying to understand things from the perspectives of people who have a different background. And then in trying to be people of good character, it's important that we consider our community to be as broad as possible. You may be a person of very good character in your community, but your community may be very narrow. It may just be your place of worship, your political party, the other people who think like you think. But if we want to be people of good character in running good prison systems across the nation, we need to consider our community to be a very broad community and uphold the best values of that broad community. So with that, that's all I've got. And it was an honor for me to serve with the rest of these people on this panel, and I'm grateful for all of you for being here and participating today.
I think that I would be remiss in my responsibility to Dr. Armstrong in the School of Criminology and Criminal Justice if I didn't say to our students, the 4 people on this panel are an example that you should do what Lincoln told young people to do. Whatever you're going to be a good one.